That case.
Charge-sheeted case, madam.
Yes, when it can be listed, what?
17th March, my lord.
17th of March.
March. That's interim you continue, madam.
Interim was there.
Well, it was initially AB, my lord. Subsequently, charge sheet filed and charge sheet was called for by the court, my lord.
But interim is still there.
Yes, madam.
After charge sheet.
After charge sheet.
Oh, I don't know, sir.
Initially, it was an AB, my lord. Court granted.
Still now it is the AP only.
Yes, my lord. Still now it is AB. And after filing charge sheet, my lord, the court has called for the TCR, my lord.
What
are you saying?
Your interim order was granted on 24/11.
Lordship.
Where is the order wherein it is reflected the charge sheet has already filed? Is there any order?
My lord, the TCR has been called for, my lord.
No, why TCR has been called for? Because charge sheet has been
Charge sheet.
listed. Now, where is the order? Where from we will get that charge sheet has already been there?
My lord, that was the
No order is there.
charge sheet has been filed.
Regarding
charge sheet.
regarding the filing of the charge sheet.
Actually, that was the submission
Can
of
you
the
tell us?
government. That's
No. Intimation is there. It is here. It is no reflection at all. In the orders.
Oh.
That case has already been charge sheeted or charge sheet number, etc. are not here in this case.
Oh, lordship. That may be, my lord, but that was them.
Simply interim is extended.
Lordship intending.
And last occasion only TCR is called for, but I don't know why TCR is called for because there's
Yes,
no
ma'am.
order at all.
Lordship.
Anyway, we could make them as well. Cases I took. Scan copy of the TCR has already been said. Estimate recording on 17th of March. So it's it will be continued. That means you are showing your charge sheet in the charge sheet. You are showing as an absconder.
No, my lord.
No.
No, my lord. I was in interim, my lord. In several occasions, CD not produced my letter on
No, whatever in the charge sheet. What is the position in your charge sheet?
Copy of the charge sheet I did not receive at all. That was the submission from the other side that the charge sheet is filed. Therefore, the court has called for the TCR.
Nothing, no order is there. Anyway. Okay.
Lordship.
May Lordship, I am trying to listing on IA Lordship.
What case?
IA Lordship. In regarding Lordship.
IA, criminal appeal, civil revision, criminal petition, revision petition, where?
Criminal revision Lordship, same as
Criminal
pending
revision
Lordship.
petition.
Yes, criminal revision petition. Same as pending Lordship.
Huh?
Section same has been pending Lordship.
Huh.
And section 5 also Lordship pending Lordship is awaited for the waited for.
Section
Lordship,
5 is still pending.
yes, it's still pending.
Date,
Lordship.
can you tell us date?
Is awaited for law.
Huh?
Service for awaited Lordship.
Is there any date fixed?
No, Lordship, not Lordship. Say here in Lordship, the applicant has arrested on 20 February, Lordship. There is some prejudice, Lordship. So on that way, Lordship, another
I
IA has
know,
filed.
is the case is fixed. So
No, not at all. So waited for the service. So after tomorrow, Lordship. So another IA has filed lordship for listing lordship. So day after tomorrow, lordship release on bail lordship.
That means your petition is not yet admitted.
Non
Because
lordship.
when,
IA, the
no,
separate
whatever,
file is pending. Lordship.
condemnation is still pending.
Yes, lordship.
Is not yet admitted.
Not admitted. So day after tomorrow, if possible, lordship.
11th of March will do.
Lordship is arrested lordship on the on state.
What to do?
So
We don't
on,
have
on
date.
Monday lordship, if possible, lordship.
Huh?
On Monday lordship,
Monday.
March.
Monday,
Yes.
2nd of March, many matters are there. Many matters.
The issue is very simple, lordship. Hearing such prejudice, lordship.
Whatever. Many matters are there.
Lordship.
Aribo. We'll go details.
IA lordship.
Okay.
Monday lordship. March of
May I please to
Any urgent belief, no?
May I please to and this IA is filed for a limited prayer matter. 10 days time was granted for appearance before the land trial court. However, I appeared on the last evening of
5th
the
of March. 5th of March.
March.
May I please, Your Lordship? Regarding item number 35, in that case, my lord, I was granted interim protection. Subsequently, though the information has not come, we have verified the charge sheet has been submitted, and I am not shown as an accused in the charge sheet, my lord.
Oh,
So matter has become infructuous, my lord. That case.
no, I don't know, but charge sheet is not for us. On
Your Lordship,
your verbal
On
submission,
my submission, because we have verified, my lord. On that
You have
submission,
verified.
my lord.
that in that case, not as per from your submission, it may be withdrawn as infructuous.
My
That
lord.
can be all. Heard Mr. S. Nawaz, Sri Lankan Council for the Petition. By the way, do you have received any? Also heard Mr. P. Bota. CD not received, however, it is submitted with Mr. Nawaz that as per their information and on what it is found that case has already been charged, wherein the present petitioner is not shown as an accused. In view of this, he wants to withdraw the same as already become. Case is accordingly disposed.
Deeply appeal.
Yeah, please. Item number 38, Lordship.
30.
38 on the
38.
daily list.
Yes,
Heavy
what is
hearing.
the position of 38?
Madam, please. Well, I found my lord charge submitted, my lord. Charge copy is with me, Lordship. So,
You have already received this as
yes, Lordship. My lord, we are shown as absconder, Lordship.
No, you will definitely be shown as an absconder. Are you on interim there?
No, my lord. They are from.
Then definitely you will be shown as an absconder only. But we don't have received, we have not received the charge sheet till date.
Lordship.
Here also you want to withdraw this one or what?
Good do, my lord. We pilot test.
But you are shown as an absconder.
Absconder.
Or at best we can make a
additional
direction that you can appear.
Lordship.
That will do.
My Sashit file, my lord, before the my lord, HDGM, my lord, planet HDGM, Lordship. But case is triable by the honorable session court. Lordship. So, my lord, bail will not be granted, Lordship. If
Whatever, we are not in a
permits,
position to
Lordship,
say anything.
if Lordship permits, my lord, I may be allowed to bring on record through additional affidavit, Lordship. Lordship will protect.
No, protection is different. Now we don't have received. We just simply will issue reminder. In the meantime, he may receive the case charge sheet. As per your information, charge sheet is there, but we have not received the charge sheet through BP. So we can issue reminder or information. You can be otherwise
Lordship may allow to withdraw this petition. I will request.
withdraw this one.
Lordship.
But
Okay.
Mr. D. Gogoi did not process same order. C did not receive, however, it is submitted by Mr. Gogoi as per the information. The case charge sheet has already been laid in the present case, showing the present petitioner as an absconder accused. In view of this, he submitted that he wants to withdraw the same as per instructions of the Act. Considering the submission made by counsel for the petition, case is accordingly disposed of. Okay, subsequently you may file.
Deeply blessed. May I please, Your Lordship? Your Lordship, I beg to mention for listing of a criminal revision petition, Your Lordship. The matter was last listed on 5/6/23, Your Lordship. And because of the pendency of the case, Your Lordship, the husband is also not paying the maintenance. Though there was order.
It is not listed.
No, Your Lordship. So any day on next week, if possible, Your Lordship.
Next week also, we have a very busy schedule, because 3 and 4 is a holiday. 5th is almost overflooded with the records.
Or a date
So
may be
let it
fixed.
be on 11th will do, 11th of March.
11th of March. Deeply obliged.
My pleasure. Here for listing criminal petition, my lord. For motion, my lord.
11th of March.
Always, my lord.
May I
I
please,
pledge
Your
your lordship. I beg to mention for listing of one criminal appeal for hearing, ma'am.
For hearing. What is the number?
197 oblique 23.
2023.
23.
19th is the hearing date. 19th of March is the hearing date. That can.
May I please, your lordship? I beg to mention a criminal petition for motion, your lordship. And it was last listed on 19/1/2026. Due to VC issues, that matter could not be taken up on that day. So
Now this time you're personally or physically they be going to appear your counsel
council
or
will be
this time
appearing
also through VC.
through VC only. your
Again,
lordship.
same problem
Your
here.
lordship,
What to do?
It
Because
did not
generally
happen
we
here,
give
your
this
lordship.
VC
No, your lordship.
at the last item as a.
No, it happened before the Honorable Mr. Justice Prithvi Jyoti Sekhia's vote.
No, whatever. Wherever it
no.
may be, I am not on that.
So
11th of March.
11,
11th of March.
highly obliged.
May please, your lordship. Lordship, I beg to mention item number 27 of the daily list. Lordship, the CD was called for, but it has not come today, lordship.
Yes, what is 27? What happened? Yes. Are you on interim there?
Yes, your lordship.
27 CD not.
City not received, issue reminder. When it can be 17/3, 16th, once, 18th,
My lord, let it be on 19th of March.
19/3, interim be continued till next.
Obliged.
May I please, your lordship? I beg to mention item number 3 for withdrawal, lordship.
Item number 3 for withdrawal.
Withdrawal, lordship.
It was in
Yes.
motion call.
Yes, lordship. The petitioner is already got arrested, lordship.
You are N.A. Begum.
Any Begum.
Item number 3, hard MS N.A. Begum, the learned counsel for the petitioner. So hard it should be voted. It should be framed soon. It is submitted by MS Begum that during the pendency of the present application, the petitioner already got arrested and hence the present petition already become in issues. Accordingly, she wants to withdraw. Prayer allowed. This is accordingly disposed of. Withdrawal is rendered in issues.
Obliged.
May I please, your lordship? Lordship, I wish to mention a criminal petition for motion, 127.
11th of March.
Please.
May I plead your lordship? Lordship, I beg to mention item number 30 and 31, my lord. Both the matter are out of same PS case, my lord. And my lord, probably charge sheet has been submitted, my lord. Interim is there, my lord.
30 and 31. You
30
have
and
any
31.
information? Yes.
30 and 31 my lord, task is submitted.
Is it out of same FIR?
Yes, my lord. Yes, my lord.
Yes. What is the CS number?
CS number my lord. CS number my lord 2/2026. Dated 15/11.
20. Oh, not 25.
23.
No, 20.
Oh, sorry, my lord, yes. Then I will have to.
Yeah, up to 25. Seems.
I'll have to confirm for here. After some time.
Okay. After time.
I'm obliged.
May it please your lordship, I beg to mention the listing of a criminal appeal, your lordship. The matter was last listed on November. your
It will
lordship.
be listed in hearing order with which
Admission,
column?
your lordship.
Huh?
Admission.
Admission column. I'll go ahead with the fine. 6th of March. In admission column, 6th of March.
Much obliged.
May I please, your lordship? Lord, I beg to mention for listing of a criminal petition for orders, my lord. Orders.
6th of March.
I am obliged.
May I please to your lordship, I beg to mention for listing a interrogatory application filed for withdrawal of money deposited by the petitioner in NI case. Money is
NI
already
case.
deposited in the bank account of High Court registry. Can
It
fix
is
it on,
pending here the revision petition.
yes, lordship.
Revision petition is otherwise pending in what stage? At what stage?
At orders,
In orders column.
yes.
Go to it.
This application filed for withdrawal of amount, lordship.
I can understand. 10th of March.
Yes, March. Lordship, I mentioned it for Friday. I have already mentioned it. Lordship had allowed for Monday, but it was not listed.
We cannot say, you just make an inquiry before the register.
Obliged.
So the other
Regarding item number 31, my lord. Excited that was 30. It was corrected. 15-1. Not 1.
15-1, huh? You were otherwise in both the matters, you were on interim.
Yes, my lord. Interim.
We are extending your interim for
Yes,
15
my
days.
lord.
Same order. Reader's CS number same. Okay.
I'm
May I
obliged.
please, your lordship? Lordship, I beg to mention item number 40. Lordship, my senior could not appear today due to some health issues. So Lordship, kindly pass over this matter for the day.
Here we have received the case diary. What?
Yes, there is not received.
Are you on interim there?
No, Lordship. There is
Interim
no.
was no interim.
No.
Otherwise also if CD is not received, we cannot hear the matter. CD not received, issue reminder. It has to come from which district?
My lord, from Tokmoka, my lord, Karbi.
Karbi Angle.
Karbi Anglong. When it can be.
10th of March.
Lordship, can it be on first week of March?
10th of March. First week is, there is no first week, in fact.
Yeah.
3rd and 4th is holiday, 7, 8 is holiday,
Lordship.
9th is not many matters, so that's why we are giving you on 10th of March. Because it is AB only. Listing it on 10th of March.
Please, your lordship. Lordship, I beg to mention item number 8 and 11, my lord. Pass over for the day, my lord.
8 and 11. Why? What is the reason?
My lord, conducting counsel, Mr. A. Ahmed had some personal difficulty.
Really, believe A. Ahmed has some personal difficulty. 8 and 11. Accordingly, the matter is adjourned for the rest. You will list him. Okay, we are listing adjourning for the day. Huh?
Much obliged.
May I plead your lordship? Your lordship, I beg to list a matter for withdrawal. It is a anticipatory bail
according-
matters. Listing a matter for withdrawal.
Tomorrow will be fine. Okay, tomorrow.
May I please, your lordship? Lordship, I beg to mention item number 43, lordship, in a supplementary list. Lordship, in this petition, there are some tactical error, lordship. Kindly allow me to withdraw this matter, lordship, to file afresh.
Your good name?
D. Datta, lordship.
Hard MSD Datta, Dilane Council for the petition. Also hard Mr. P. Board, Dilane the district of states. Submitted by MS Datta, Dilane Council for the appellant, that there are some typical error in the appeal memo, and hence she wants to withdraw the same. We delivered it by prayer and matter is accordingly disposed of withdrawal. We delivered it by the
May I please, your lordship? I beg to mention for item number 32 and 33. I have instruction to withdraw them.
32 and 33, my lord, case diary is
Interim was also there, lordship. It may be vacated, lord.
maybe vacated.
Interim may be vacated. Interim was there, lord.
What are you saying? Why interim should be vacated?
Ultimately, when it may be disposed of, lordship, it will automatically vacate.
He's saying that automatically it will be defective.
Yes, 32.
You want to withdraw the same?
Withdraw.
The interim is there, that may be bottom.
Why? What is the reason? You have got
I have
arrested.
instruction, lordship. to-
Instructions.
Instruct.
Otherwise, we have received the case diary.
Case diary is.
You are Mr.
R. Hawk, lordship.
R. Hawk. R. Hawk with the same order. Mr. R. Hawk. And also for the petition and also hard Mr. P. Bottle and so. CD received, but it is submitted by Mr. Hawk that as per instructions of his client, he wants to withdraw the application. In view of this, the petition is accordingly disposed of on withdrawal. Interim granted earlier be vacated. CD petition.
Obliged.
May it please your lordship. Lordship, I beg to mention for listing of a criminal revision petition for motion.
10th of March.
Obliged.
Lordship, I'm so sorry. Lordship, on 10th of March, we have a matter fixed on Kohima. Lordship,
In
So-
which item you are saying?
item number 40, 40.
40.
Lordship,
9 point. Okay, then 9th of March.
9, 10, and 16, 17, we have matter on 0, Lordship. So between
11.
11.
May I please, okay. Actually, here the petitioner approached this honorable court, my lord, against the GD entry, my lord. Only a GD entry has been done, my lord, against which he has approached this court, my lord. What happened, my lord? The petitioner wife has lodged an FIR before the All-Woman PS, my lord, and that has been made a GD entry, my lord. And the All-Woman PS, my lord, the police personnel
You
are.
have annexed the copy of the GD entry also?
No, my lord, we have not received the copy, my lord, because that has not been received. my
Number
lord.
is there.
Number is there, my lord.
Your probability in under which section it is registered?
Because they have not intimated anything, my lord. What happened, my lord? The police personnel is calling, my lord. I have stated in page 5, my lord, para 7, my lord. One mobile number as given, my lord. From this number, my lord, the police personnel is calling and ask him to appear before the police personnel, my lord. But they have not issued any notice, my lord. Under the provisions of law, my lord, 35 notice may have to be issued, my lord. Without issuing notice, only
No,
phone.
under which section it is? I mean,
They have
that's
not
why I'm-
intimated, my lord, under what section, my lord, their case has been registered.
Because it has to be within 7 years, then only
Yes, my lord.
35(3) will go.
Whatever, my lord, there is a family dispute going on between the petitioner and his wife, my lord. I have annexed the copy, my lord. At page 10, my lord, the petitioner has filed a judicial separation petition, my lord, at Dimapur, my lord. Petitioner and informant both are staying at Dimapur, my lord. She came to Gauhati on 13th of my lord, 13th of February, my lord, and she asked the petitioner to withdraw this case. Otherwise, she will file a case, my lord. On 14th, she lodged this FIR, and thereafter the police personnel are calling the petitioner to appear before him, my lord. That's why the petitioner is apprehending, my lord. But they have not issued any kind of notice, and
I will get a detailed report regarding that GD entry number.
well, till then, my lord, he may be allowed to protection may be given, my lord. Because he has a showroom, my lord, in Gauhati, my lord. Police personnel visited there also, my lord, and inquired about him, my lord. And it is purely a matrimonial dispute, my lord. I have annexed the petition, my lord, at page 10, my lord.
Hawari Dilane petition. After we bought for Dilane will be appearing on tickets. This is an application of section 482 BNSS for granting 2 years respect to the accused petition. With the apprehension of arrest in connection with all one police station. Panpuja. It is submitted by Mr. Next, submitted by Mr. Hawari that they have come to know that one GD entry has been made by number 15 GD entry number, sorry, one GD entry number has number 15 of the 15 dated 14/2/2026 has been made in all women police station on the basis of an FIR lodged by the wife of the present petitioner, and on the basis of which the petitioner is calling and threatening by police of the said police station. Though till date he has not received any notice under section 3 BNSS. The further submitted that earlier one judicial separation case was filed by the petitioner, and his wife of the respondent was threatening for betrayal of the scene, and in that view she might have lodged an FIR before all 11 police station. He accordingly submitted that the petitioner may be provided with some interim protection. Next, Mr. Botpur Ilani Division PP submitted that he will call for a detailed report from the concerned police station and raise objection in granting any interim. Considering the submission made by the for both sides, let a detailed report be called for from the Parliament police station as to whether any case has been registered against the present petition. And in the same time, till the receipt of the report, the police from the Parliament police station is hereby directed not to take any corrosive action against the present petition. Listed when it can be listed.
19-3 man.
19.
Obliged, my lord.
May I please, your lordship?
Please.
I filed this bail for paying for a pre-arrest lordship. Here, lordship, what has happened, this petitioner is having some relationship with a lady, but the petitioner happens to be a married person. Therefore, morally, although it's not correct, lordship. Now, what happened, this lady with whom this petitioner is having a relationship, he is pressing hard that you give divorce to your wife and marry me, otherwise entered into a contract of paying 50 lakhs. Now, with this, she lodged an FIR before the Udal Wakra outpost, that is under dispute PS. On your lordship, may kindly see page number 5, lordship, paragraph number 12. On 16/2/2026, this petitioner was called by the police and police pressurized him. The whole day he was detained, police pressurized him to enter into a contract, which of course is not, cannot be, because it is against the public policy. It is not an enforceable contract. Now, although he was
What kind of contract?
contract agreement with that lady that within 2 years he will give divorce to his present wife or else pay 50 lakhs to him, that if he does not give a divorce. And she also wants the access of CCTV to his home residence. For that, on 16/2/2026 whole day he was made to sit. Only after he has given access to the CCTV footage, he was allowed to come. Now, lordship, I am apprehending that I may be arrested at any moment of time, lordship. Although we could not find any FIR, lordship, may kindly call for a status report, lordship.
Could you collect any GD entry also? No.
That part also we don't know, but police is looking after me, lordship. Continuously they are coming to my home, harassing my old mother, my sister. For some official purpose, I am not there. But moment I reach Gauhati, I may be arrested, lordship. Lordship, may kindly call for a status report, lordship. And in the meantime, lordship, I may kindly be protected, lordship, because at any moment of time I may be arrested. Till 7th, we tried our level best to find out whether anything is there or not. 7th only we have filed this petition, but we could not find out anything. This Monday, last Monday. 23rd. 23rd. This is what is happening, lordship. What can be done? Lordship,
Why he was maintaining with us illicit relationship with the
yes,
lady?
yes, that is, lordship, not morally correct, lordship. I will also not support it. But actually, what has
What
happened?
is her, you have to disclose her name here? No.
Yes, I have disposed of. And lordship, she is, if my instruction goes, she is around 43 years of age. So she also knew the consequences. They came to know each other from Facebook, lordship. And when first time she insisted for a meeting, this petitioner went with her daughter. So she knows that he is married. And she also knows that some hitch is going on between this petitioner and his wife. Taking advantage of that, he is saying, you divorce your wife or else entered with a contract and give me 50 lakhs rupees. Otherwise, these things have been already mentioned in the petition, lordship.
Prima facie, otherwise, my lord, he has committed the offense for which my lord police
No,
is.
lordship will kindly see to my friend what my friend says. Adultery may be a ground, lordship, for divorce.
But what to do, Botakur? This Facebook, this
I am praying, lordship, a status-
Instagram reels, these
Yes,
are doing a very bad impact in a society. A woman having children also leaving her husband, she's going somewhere. These things are going.
Things are going on, lordship.
I will get the report.
Pardon stay for the site till and council. Council administrative report to put it on an additional PPA. This is an application under 482 PNSS for granting various bill in favor of the petitioner who is in apprehension of arrest in connection with Hotel Bakra outpost under which police station?
It is Dispur Police Station, Udalbakra Outpost, Lordship.
That is police station. Is
The
submitted-
cause title needs some correction, Lordship. It is mentioned
yes.
only Udalbakra Outpost. Dispur PS needs to be added if your Lordship kindly allows me, Lordship.
Okay, passing the order, second time subsequently we'll pass the order. It is submitted by Mr. Authorised that then this petition had some relationship with one lady, namely X. But subsequently she regularly pressurized him to marry her by divorcing his wife. And on his refusal, she threatened that he has to enter into an agreement either to divorce his wife or to give her 2 lakhs rupees to us. In that context, she already lodged a complaint before Dalbakra outpost under Bispur police station. And on 16/2/2026, the petitioner was asked to appear before Dalbakra outpost, and he was detained for the whole day. And also the police also harassed him to make an agreement with the said lady. In view of this, he is submitted that some protection may be, however, he submitted that he is ready and willing to extend his cooperation in the event of any registration of this case, but till that some interim protection may be provided to the present petitioner. Mr. Border raised objection in providing any interim protection, submitted that he will call for a detailed report from Ural Bakra outpost under Dispur police station as to whether any case has been registered against the present petitioner in this said outpost. In view of this, let the police report be called for. The learned additional people will take necessary steps. Until the receipt of the report, it is directed to police of the Ural Bakra outpost under Dispur police station not to take any corrosive action against the present petitioner with the receipt of it. List demand accordingly when it can be listed.
On 18/3 months. 18/3. I am deployable, Lordship.
May I please, Your Lordship?
Yes.
Lordship will find the FIR, so the nature of the allegations are a bit serious, my lord. Lordship will find the FIR page 17, Lordship. Vernacular is in Bengali, my lord. Lordship will find the relevant portion from page 18.
Yes.
I humbly beg to state that I, along with my family, have been residing for many years in the area adjacent to the east-west part of the END embankment, Hatikhal market, by constructing dwelling house and also carrying out the business from the said place. We have also let out few of our houses to different people and thereby carrying out business. The above named accused persons few days ago has threatened the shopkeeper for evicting them. On 14/12/2025, I lodged a written complaint in the police station regarding the same, for which the above named accused persons, out of rage with the intention to kill me and my family members, came in a group on 15/12/2025 at around 10:30 p.m. and illegally trespassed into the dwelling house and the road. After entering, they attacked us with sharp dagger, stick, iron rod, bolom, etc., and suddenly started assaulting us, for which my family members, namely Sadia Akhtar, Suhab Ahmed, Abdul Gafur, Abdul Kalam, Afzal Hussain, Anwar Begum, Mukhtarul Islam, Akhtarul Islam, sustained injuries due to the assault inflicted by the accused number 1, 2, 3, and 7 by their sharp weapon. 3 persons, namely Sadia Akhtar, Suhab Ahmed, and Abdul Gafur, are presently admitted in SMCH in an unconscious condition by sustaining serious injuries. Lordship will find altogether 22 persons have been named in the FIR, my lord. Almost the known person from that locality has been named in the FIR without attributing anything to them, my lord. The present petitioners before your lordship are working as a teacher
Lordship will kindly come to page 24, Annexure 3. That is the Anwar Hussain Ahmed. He is working as an English teacher at Golden Valley English School. And page 25, Lordship, Altaf Hussain Ahmed. He is a Hindi teacher. They were residing in the same village. And the previous year, regarding some admission issues, my lord, there was an altercation between the informant and the present petitioners. And that is why their name has been implicated. Lordship has already considered the bail application, previous bail application of the two of the co-accused, my lord. Lordship will find that order at Annexure 5, page 26, Lordship. Abbasuddin Ahmed and Komoluddin. Considering the fact that, Lordship, the only accused number so far the FIR is concerned, the accused number 1, 2, 3, and 7 has been specifically implicated that they have attacked with sharp weapon, my lord. The present petitioner's name appearing in the serial list, my lord, 12 and 13. Serial number 12 and 13 in the FIR. We are not at all involved with the attack, my lord. Only because we are residing in the same village, our name has been known by the informant, and there is a previous enmity regarding the admission issue, my lord. Our name has been implicated. We are ready to cooperate with the investigation, my lord. We may kindly be protected.
Yes, my lord, although my lord in the FIR specific allegation against 1, 2, 3, and 7, but all these accused persons were my lord actively participated, my lord, with their FIR name accused persons.
Pardon, that's the learned counsel for the petition. And also heard Mr. P. Waterford, the learned counsel of the PA, Next, it is submitted by Mr. Das that present accused petitioners are used. They are not involved in the instructions. The from DFI itself, it is seen that altogether, how many witnesses accused are there altogether? How many accused persons are there altogether?
Lordship, 22.
18.
Persons have been named in the FIR.
22.
FIR 18 total.
22. 22 persons have been named in
No,
the
it all take it again.
and the
22, my lord.
persons have been named in FIR. All the accused persons are not involved in the documents. The petitioner are accused number 12 and 13 in the same list, and both the persons are teacher by profession, and there was earlier dispute with the informant regarding the admission issues of their children. However, in the petition, there in the FIR, specifically the name of accused number 1, 3, and 7 have been mentioned who attacked the informant side with sharp object. However, these petitioners are ready and willing to extend their cooperation in further investigation of this case if they are granted with some interpretation. Mr. Waterford, the learned additional PP submitted in this date to the name of respondent accused number 1, 2, 3, and 7 are mentioned in the FIR. We alleged to have assaulted with sharp object, but all the accused persons are equally involved in the alleged offense. Hence, he insisted to call for this study. Next, considering this submission made by learned counsel for both sides, all other circumstances of this case, this board is of opinion that some interim protection will be provided to the present petitioners so that they can help you and cooperate in the investigation according to. Okay, you will be under interim protection.
Lordship, on 9-3, it has been fixed for case day.
9-3, what? 26.
1926.
26, same one.
Along with the AV number, my lord, 253 of 2026.
9-3, 2026, along with the AB number?
AV number 253 of 2026.
Along with the AB number 253 of the 2026.
Deeply always, Lord.
May it please your lordship. Lordship, this application is filed on anticipation of being arrested by the petitioner by the Shankardev Nagar outpost, lordship. So now, lordship, the gist of this case is such, lordship. Lordship. Lordship, at the first place, this dispute in question is purely of civil nature. What happened, lordship, the informant here, Shilpi Saura, when her husband died, she took financial assistance from petitioner and at various point of time. And discharge of that, acknowledging the discharge of her liability, lordship, she issued a check in the year 2025, lordship, of amounting to rupees 10 lakhs. Now, lordship, this 10 lakhs has been credited in the account of the petitioner that I have annexed at page 8, lordship. Page 8. Down from bottom, lordship would find 18/4, statement dated 18/4/2025, that it's a check, Silpi Shaura, credited in the account of the petitioner, lordship. Now, lordship, as lordship is aware that every bank officials are now bound that first, while before crediting the any amount above than 1 lakh, they inquire with the person who issued the check. So accordingly, that confirmation after being satisfied, the bank has credited the same amount to the account of the petitioner, lordship. Now, lordship, now after the lapse of 1 year, now she lodged a complaint in the outpost, lordship, and as such, lordship, outpost of Shankardev Nagar is constantly harassing and threatening the petitioner of being arrested. That is why this petitioner before
What
your
kind of complaint?
lordship, that she has been forced and she was forced to issue the check. That being the situation, lordship, 1 year lapse of time. This has been the statement will reveal, lordship, and that is why I have annexed the statement, lordship. It is of 18/4/2025, almost a year, lordship. Immediately, she could have filed a complaint within 1 day, 2 days, and she should have filed a complaint before the bank official also, lordship. That. But what I have been instructed that bank official has taken approval because it is a mandatory procedure now. Because even I also issue any amount of check, whether it is 1 lakh, the bank official will definitely inquire with the one who has issued the check. Thereafter they are bound to do so. It's a mandatory guideline. So this procedure, all procedure has been done. Now after the lapse of this 1 year, she has come now for her wrongful gain. Now she don't want to, she want to snatch it again from me. She took the financial help on the discharge of her legal liability. She issued that check, and now when she want it back again. So that is the situation now. So purely civil nature, lordship. May I pray, lordship, that no coercive petitioner will cooperate with the police station and no coercive action be taken against him.
Yes.
Otherwise, my lord, petitioner has explained in detail about the complaint, but regarding that complaint is not with me. at
Yes,
present.
lordship. Now
So
the
I will
police
have to-
also not
I will
disclosing
have to get the instruction, my lord, whether any
Yes.
case registered against that
meanwhile, lordship.
and what type of complaint regarding that.
But nowadays the bank make an inquiry.
Yes, yes,
Generally make an inquiry if the check amount is more than 1 lakh.
yes, yes.
That is in every bank. Now it is different.
Yes.
No, this amount they have shown is this is the amount or subsequent any amount was there that we don't know.
Yes.
But what check was there, I think. But we cannot say what is the other matters.
Yeah.
Any RDMST is only learn but report the learned additional PP every it's an application for pre-arrest bill, whereas the petitioner has apprehension of arrest in connection with some outpost, police station, Lanka police station.
It
It is submitted by her. The present petitioner had a good relationship with one Shiva Sarora, Saora, Saura, and after date of birth, she financially helped said complainant, and when she returned, and the money was also returned to her with a HDFC bank check of is 10 lakhs. 10 lakhs, and that was issued to her on 18/4/2025, but thereafter, after about 1 year, she lodged a complaint before the petition, and for which the police from the Sankadev outpost is now harassing the petition post. That they do not know that the case has been registered. But this case is purely civil dispute wherein the monetary transaction is accordingly she submitted that in the respect of the report she may be protected. She may be provided with some candidate may be provided that he will take instructions of the report from the concerned police station. Any case has been registered against the present petition. Next of this, let the detailed report be called for from Sankadev outpost under Ronka police station, and till the receipt of the report, the police officials from Sankadev outpost under Ronka police station is hereby directed not to take coercive action till list the matter accordingly when it can be listed. What about when it can be listed again? 18 or 19?
Yes, 19 May.
19.
interim is there. I'm deeply obliged.
6.
Yes.
May I please, Lord? Lord, we have challenged the order, my Lord, dated 29/9/2025, my Lord, page 40. Here, my Lord, the marriage took place, my Lord, on 24/4/2016. Then in 2018, my Lord, the wife left the house and filed a case, my Lord, under section 498A. And thereafter, she filed another case, my Lord, under section, my Lord, 12 of DB Act. Husband filed, my Lord, petition for restitution of conjugal right. Then, my Lord, matter settled, my Lord, and case was withdrawn. In 498A case, my Lord, after full trial, my Lord, husband was acquitted. Thereafter, my Lord, she filed a case under section 125. And parallelly, my Lord, under section 12 of DB Act. Both the cases was, my Lord, pending. And in the DB Act, my Lord, Lordship page 31, the learned court, my Lord, granted interim, my Lord. Page 31, Lord.
Yes. Yes. What is the interim?
Page, the relevant portion on page 33. 4,000 and 1,500 each, my Lord, 7,000 total, my Lord. And husband is paying, my Lord. And subsequently, my Lord, in the 125 proceeding, final order has been passed on page 40. And findings, my Lord, you Lordship will find page 45. Paragraph 15, my Lord.
Yes.
May I read, my Lord? Paragraph 15, my lord. PW1 so and so in her statement stated that for last 3 years she has been staying at her house of her father along with her minor son and daughter. She has added that the second party used to neglect her and used to misbehave her and obscene language as and when the second party visited his house.
Okay, these are the evidences from her
There
side.
is
So
there
what
is no,
the
my lord, any
order?
allegation of cruelty or anything, my lord. And in 498A case, my lord, as well as my lord, section 4 of the DB Act, my domestic dowry act was added. In that case, he has been acquitted. Now he is paying, my lord, as per order of in the case of DB. Again, this order has been passed, my lord. As a result, my lord, he is paying double, my lord. So, my lord, I am paying, my lord, regarding wife maintenance, my lord. That's my statement.
So now here in this case, what is the amount of compensation? Directed to pay rupees 9,000.
Lordship.
First party and treatment.
Here 16,000 and earlier, my lord, 7,000. Case 50, my lord. And there is no finding that the husband has been any kind of negligence on his part. Merely, my lord, allegation that use obscene language, so she left the house.
But you are not paying in both the matters. Payment was there.
He's paying, my lord.
Where he is paying? In DB case also in one.
Yes, my lord. In DB case 7,000 he's paying, my lord.
Ah.
And now, my lord, again, my lord, fresh order has been passed in 125 proceeding.
In 125, he has not paid a single money also, I think. Till date. He has not paid anything, I think.
No, he's paying, my lord, but area has not paid.
So just tell us whether in the present 125 he is paying anything.
My lord,
I don't think so. He's not paying a single penny.
that instruction, my lord.
Why you have not taken instruction? Because this is the tricks.
Or she
And
may taken
because in
after some time, my
125
lord.
there are, because
Whether
you
he
could
has
have
paid,
raised
my
the
lord.
issue, you could have raised the issue that in DB case he is paying so much that could have adjusted.
Lordship.
Because one person cannot
No.
pay in in
Lordship.
DB case and 125. That cannot be. I can understand, but you have not paid anything till.
But lordship may take after some time, my lord. I'll take instruction regarding payment, my lord.
We are not going to stay the anything. Rather we may make a observation and you may pay 9,000 per month, away from 9,000 per month. Acha, acha. Now 16,000.
Lordship.
Out of 16,000, at best you can pay 10,000 per month. Then only we can stay. Otherwise,
Lordship.
we should. State is a party, formal party here or no?
Lordship. State is not party, my lord.
Not the party, no?
No.
Mr. R. Send petition. Section BNS second Implement dated 10/11/25 passed by learned principal just before Forfeta in FC criminal case number 816 under section 125 CRPC directing the petitioner to pay maintenance of rupees 9,000 to the respondent and the rupees 3,500 each to her two minor children from the date of filing. It is submitted by Mr. Ali that earlier the present respondent had lost two cases against the present petitioner, one under DPA and one under 498A IPC. In both the matters, 198 IPC, and in the same time, the petitioner also instituted case for restitution of conjugal rights, but subsequently, due to compromise, the DV case as well as the restitution of conjugal rights cases were withdrawn by the petition as well as the response and And in 498 case, the present petitioner got acquitted. But thereafter, she again lost 1 dB case, where the order was passed for payment of rupees 4,000 for the respondent and rupees 1,500 each to her 2 minor children. Thus, he is paying rupees 7,000 per month in the said TV case. But subsequently, in the case of 125, and the order of maintenance, an order of the judgment was passed wherein he was directed to pay rupees 9,000 per month the respondent and rupees 3,500 each for her 2 minor children. He is still paying the maintenance for the TV case, however, without mentioning about the maintenance already awarded in the TV case. The learned principal judge had passed the order directing petitioner to pay rupees 60,000. It's up that the state till disposal of this order, judgment and order may be state till disposal of. However, he is ready to pay rupees 7,000 per month as directed by the court of as the court may be proceed. Next, hearing the submission made by learned counsel, the petitioner is hereby directed to pay rupees 10,000 per month till till next date of listing, and in the same time the notice here be called and also issue notice to the respondent through speed post and email. Is the matter according to court. Now you pay 10,000.
10,000. Obliged. Wait, please. My lord, I file a CR case, my lord, before the trial court, my lord. So, my lord, your lordship, in the CR case, my lord, your lordship would be pleased to turn to page 22.
Yes.
22 para 9. So, my lord, I went to Vilashipara, my lord, along with my wife and children. And there was some dispute, my lord, arises at Vilashipara. I am practicing lawyer in Gauhati, my lord, at that time. So, my lord, what happened? My car has been snatched away from me. My wife and children came to Gauhati and threatening me that if you come to
arrange
Gauhati.
here.
Yes, my lord.
Now your case is properly arranged here.
Yes, my lord. Now, your lordship, in para 10, my lord, I have detailed what is the properties in the custody of the accused persons. That my car, I am in legal profession, my books, my case files, my lord, and all everything's in my residence at Gauhati, and that has been under the custody of the accused persons. Now, my lord, I prayed before the learned court below, my lord. My prayer, your lordship would be pleased to see. At page 30, that cognizance may be taken and search warrant may be issued. Thereafter, my lord, your lordship would be pleased to see the interim order, impugn order as page 68, my lord. Your lordship, see that prayer is this, that cognizance may be taken against the accused person under certain law and search warrant may be issued. And thereafter, your lordship would be pleased to see page 68. Is the impugn order, my lord. It starts from 69.
So, my lord, after discussing, my lord, hence here in page 69, my lord, last but one paragraph, after hearing the parties and perusal of case record, including petition and the statement of the complainant and his witness, I find that there is sufficient ground for proceeding against Gulera Khatun. There are 6 accused persons, my lord. Your lordship would be pleased to see 6 accused persons in the contempt case. But only one person has been taken cognizance of. That is first allegation, my lord. And lastly, my lord, cognizance is taken of the accused person mentioned above, issue summons to the accused person. Further, court deems it not to be a fit case. That is very objectionable, my lord. My car is under their custody. My bike is under their custody. My books under their custody. My profession is totally hampered, my lord. And with books, my lord, she can do nothing. And registration of car in my name. Bike is in my name. They are running the vehicle, my lord. If they run the vehicle, there may be some accident, some objectionable articles may be carried in the vehicle, my lord. Then what will happen to me, my lord? So, my lord, they have no right to keep the vehicle in their custody. My books, my case files. So I prayed before the court below that search warrant may be issued. And after searching, if these documents are found, my vehicles are found in their custody, that may be handed over to me. My lord, now the court said that court does not deem it fit to issue search warrant. So this part I objected vehemently, my lord. What will happen to me if my car is involved in some criminal case? If my vehicle is involved in some criminal case, how they can run the vehicle? And what happened, my lord? They have filed written statement. And on my para 10, my lord, they have given a evasive reply. They said that these are not true. They did not say that the vehicle number so and so not in our custody, that car is not in our custody. That is not said. Thus it is said, a evasive reply has been given. That no, this is not true. That is not sufficient. So, my lord, my humble submission before your lordship that order is not proper order. So, my lord, I am entitled to get search warrant. So, my lord, my prayer, your lordship would be pleased to see what is my prayer in this petition, my lord. Your lordship would be pleased to see the page number 9, my lord. I have specific grounds, my lord. Specific grounds. Now your lordship will turn to page 11, my lord. Under the above facts, therefore, prayed that your lordship would be pleased call for the records issued cause as to why the impugn order dated so and so, magistrate first class, shall not be set aside and quashed, and to show cause as to why prayer made in the contempt case the criminal case, CR case shall not be allowed. That is my prayer. And further prayer is that, my lord, pending disposal of this criminal division, my lord, further proceeding may be taken. My lord, there are 6 accused persons. They clap together, my lord, doing this nuisance against me.
Staying of further proceeding will help you.
My lord, because, my lord, only cognizance taken against one accused person. If the case will proceed against one person. Thereafter, supposing your lordship allowed that cognizance is to be taken against 6 persons. In that case, there will be again delay in the matter. Again evidence, my lord, again this matter will be delayed. So, my lord, if your lordship allowed that cognizance is to be taken against all the accused persons, there is grievance in the long run, my lord. In that case, my lord, there will be another round of litigation. That evidence is to be provided, etc. That is why, my lord. From looking from one angle, my lord, I am not benefited. But another angle is this here.
Snap it. against it order dated 4/11/2025, passed in CR case number 484/24 by learned JMC and Gauhati, whereby the learned trial court declined to take cognizance against the other accused person were named in the said complaint case, and also declined not to issue search warrant as per issuance to the. But now, under what strength you made these respondents as a party?
My
They
lord.
are not. They are not before the court. Not before. How?
My lord.
How you can make all these persons which were named in the your complaint petition
My lord.
as a party respondent here?
Here, my lord.
Because now they are nowhere in the picture now.
No, my lord, they are involved in the case, my lord. That is why.
But you cannot. How? They are not at all party to the earlier case. You cannot.
In
make
the
them
earlier
party.
case, they are their party, my lord. In
They-
earlier case.
At present, they are not there.
My lord.
At best, you can make party. The state can be made party.
No, my lord, I could not follow your lordship.
How can you make party the other respondents?
Other
They are
respondents.
not at all there in your picture now. Against them, there is no case. Against them, there is no cognizance taken by the court. So
No, my
how
lord,
they can?
that is my grievance, my lord.
That is your grievance, but they are not the picture in the picture.
But in the complaint, my lord, they are the party.
You
In the
cannot.
complaint petition, they are party.
You cannot now.
My
They
lord,
are nowhere.
No,
Nowhere
but-
in the picture.
no,
How
no.
can you bring them?
My lord, in the complaint, let me put, let's be
In the
clear.
complaint petition, I can
In the
very
complaint
understand.
petition, they are
In
the party.
petition, they are the party.
Now, my prayer before your lordship, cognizance may be taken all the accused person. That is my thing, my lord. My lord,
We cannot now.
my lord.
They are not
Cognizance
the
may be
party.
taken. I may be incorrect, my lord, but my contention before your lordship is this. At present, I am praying before your lordship that cognizance may be taken against all persons. Against all persons. If they are not party, my lord. Tomorrow, if your lordship decide that my prayer is correct, that they should be take
There
cognizance
may be a
against them.
direction in that case.
My lord, in that
There
case,
may
my
be a
lord,
direction in this case. In that
direction, if your lordship pays the direction, that they may be make accused in the case. In that case, what they will come with another
Why don't
feeling.
you file an application before the learned trial court below itself?
My lord,
Learned trial court below under 319, they could have made the party now at this stage also.
my lord,
Under 319,
Why
I don't
learned-
know now,
learned
now the
trial court,
provision
my
is
lord?
maybe different.
my lord, when learned trial court already taken a decision that cognizance will not be taken against other persons, then I am to agitate the matter before your lordship.
But now these are not before us.
They are not before your lordship. But thing is this, my lord, if tomorrow your lordship interfere with the order of the
Bring a
learned trial
person
court,
without anything.
my lord,
How can you bring a person without anything? Against them, there is no case. Against them, there is no cognizance. How they will appear now?
no, my lord,
On what strength they will appear now?
they were not taken cognizance, my lord. That
At
is
this
my
stage, they
case.
cannot
Why
be.
they will not be taken cognizance? Because I have allegation, direct allegation against them,
No, sorry.
my lord.
Sorry. We can only issue notice against one, not the rest of the others.
But your lordship, subject to correction by your lordship, that if your lordship interfered with the order of the learned trial court and taken the view that all accused persons should be taken cognizance of, in that case, my lord, there will be another feeling on their part that Honorable High Court, without hearing us, make us accused in the case. In that case, my lord, how your lordship will interfere with the order of the learned trial court?
If order, you make a submission. You
Madam.
make your submission. Will peruse the record.
Madam.
What is the available materials against the present petition? Then
My
it
lord,
can be
because your lordship would be pleased to see page 10,
going to see.
para 10, my lord.
No, I'm
Para
not going
10.
to see now.
There is
What is the
specific allegation.
materials? What are the materials? On the what basis the court declined to take cognizance and the other prerequisites, that will be perused by us, this
Madam.
court. And then only if this says that this order is liable to be reviewed or revised, then it can be. But at present, they are not before us.
Madam.
They're not the accused.
Madam.
against whom you have filed the petition, they are not the accused. Against them, there is no case at all at present.
Yes, my lord.
Subsequently, after hearing you,
I'm
after recording of the
go by your pointing out by your lordship. I go by your lordship. Supposing your lordship interfere with the
in
order.
that case, we'll make a direction to the learned trial court below that issue notice to all the petition, all the other accused in the case.
Well.
Because at present there is
Well.
nothing for us. That's
In that case, my lord, they may be deleted, my lord, from the party, my lord.
you may file an additional affidavit. In
My lord.
At present, we are listing only on against because at present, issue notice only against the respondent number 1.
No, my lord,
Only
as
against
your
the
lordship,
number 1.
as your lordship pointed out, I may be,
Also,
these parties may be deleted out, my lord, on my prayer, my lord.
And considering the prayer made by Learned Counsel Mr. Sheikh, the name of the other respondents, that is the respondent number 2, 3,
Accused number 2 to 6 may be deleted.
3, 4, 5, and 6 may be deleted from the post title of the petition at the risk of the petition. Also, for the scan copy of the TCM, place the matter accordingly up. 3 weeks will do.
My lord,
You want any fixed date here?
deleted, my lord.
Yes, it is already deleted. Want any
Deleted,
fixed
my
date?
lord.
Any further proceeding you state?
Yes, my lord, and
Further
another
the
prayer is
next
there, my lord.
submission made by
Another prayer is there, my lord.
the further proceeding in CR case number pursuant to the state till next date. Please the matter accordingly. Want here fixed date any?
My lord, further proceedings, moreover, my lord, page 13, your lordship may be pleased to see that respondent number 1, that is Gulera Begum, my lord. She may be directed not to drive my vehicles, my lord.
We don't know here whose car is this, how she has come, how he is taking, how she is taking over
My
position.
case is this, my lord.
How we at this stage, how
No, my
can we
lord,
know?
I have stated before your lordship registration in my name.
You were there, you went
Yes,
there.
my lord,
It's there.
let her appear.
I cannot.
Yes, my lord. Further proceeding is state, my lord.
Further proceed.
Yes, my lord.
Yeah, but you fix it one fixed date here or
Fixed date may be given, my lord. After 3 weeks.
20.
20. Oblige, your lordship. Much so, my lord.
Okay, what is it?
May it please, Your Lordship.
Yes.
We have come against the interim order passed by the Learned Family Court regarding interim maintenance, the child of the respondent. My lord, may come to the impugn order at page number, my lord,
What for the money?
69, voluminous, my lord, because of this account statement. 697. Operative portion is the next page. 698.
Separate.
It's 98, the operative portion.
Yes, 697.
697 is the starting operative portion, the next page, 698. My lord, may I read, my lord? Petitioner, third paragraph, my lord. The petitioner in her affidavit as a celebrity, that is the respondent here. The monthly income of the opposite party is stated about 1 lakh from his business, and the opposite party in his affidavit of assistance liability mentioned monthly income 10,000. My income is 10,000. I have filed affidavit of assistance liabilities by working in PD Enterprises as cashier and driver. Upon hearing both the parties, considering the fact the case of income of both the parties, the opposite party is directed to pay 9,000 as interim per month to the petitioner as interim maintenance for their minor child till disposal of the case. My lord, minor child is, my lord, 5 years of age. Lord, my marriage took place in the month of February 2020, and in the month of April, she went back to her parental house. My lord, Thereafter, they have filed this
2020.
case. My lord,
Marriage took place on 2020.
2020, February 2020.
And she?
She went back April 2020, after 2 months. My lord, may now come to page number 456, that is assets and liabilities filed by the respondent herein. Sorry, madam, the application is below. Volume must be to the account statement of 456, if I got it. This is the assets and liabilities filed by the respondent herein. The next page, you'll also will see page number 457. The marriage date 10/2/2020, date of separation 28/4/2020. Then, my lord, general monthly expenses of the applicant in point number 2, child expenses 7,000 approximately. My lord, for child, she is spending 7,000 approximately as per her assets and liabilities. My lord, may come to page number 460. City, details of income of the deponent. My lord, she has projected her monthly income as, my lord, 15,000, and she is the owner of a beauty parlor. My lord, may turn to next, my lord, page number 464. Here, the net income, my lord, net income from the business of employment is 50,000 per month. She is having here. She has mentioned this. Her income, net income from the business is 50,000. And my
Whose income? Her.
Her. She has herself mentioned, my lord. 464. This is the affidavit of assets and liabilities filed by the respondent hearing. And towards her child, she is spending 7,000, my lord, admittedly. And my lord, may come to page number 236. That is the assets and liability filed by the petitioner hearing.
It is her.
236. This is the petitioner's income, my lord.
Property or who?
It starts from, my lord, page number 232. Relevant portion is 236. Is the details of assets and liabilities by the petitioner. Relevant portion is 236, my lord. Here, my lord, I have reflected my income, designation, cashier and driver. Monthly income 10,000, my lord. Now, my lord, done a trial court, my lord, without taking into consideration income of the respondent, she has, my lord, granted 9,000 rupees as interim maintenance towards her child. I am not objecting to pay my lord maintenance, but thing is that the quantum is, my lord, not satisfactory, my lord. I am earning 10,000, my lord. If I pay for 9,000 rupees, I am having ailing parents with me and sister also, my lord. And recently, my lord, in the month of October, I met with an accident. I had to be bedridden at least 2-3 months, my lord. I am not telling that I will not pay maintenance to my child. He is my child. I am ready to pay. But thing is that, my lord, the quantum of interim maintenance which has been granted by the learned trial court is exorbitant. My income is 10,000, my lord. If my 9,000 I will pay, and on the face of it, on the record itself, she has claimed 7,000 per month as a maintenance for the child. And my lord, in this regard, my lord, the Supreme Court in Rajneesh versus Neha specifically mentioned that
But
if the
her statement shows that your income is 1 lakh.
1 lakh. Well, that
Yes,
will be,
her SSN liability is also shown.
yes, my lord, that will be proved during the trial, my lord, that she'll have to prove, my lord. I'm not telling that I will not pay I am ready to pay maintenance for my child, but the amount which has been granted, my lord, 9,000 for a 5-year-old child, my lord, is exorbitant. And my lord, if both the parents are earning, my lord, then Supreme Court has deliberately said that it has to be decided proportionately on the basis of earning by parents, my lord, regarding the child.
You have a hardware shop,
I am working as a driver and cashier in a hardware shop, my lord.
then PT Enterprise. So having landed.
And my lord, for my treatment, I have taken loan from my employer, which is being adjusted from my salary.
10,000 you have taken loan also.
Yes, my lord, because in the month of October, I met with accident. I was taken to Patna for operation. I have been operated. In one agreement has also been executed with my employer, my lord.
You are Mr.
My
Your
lord,
good name.
A. Roy, my lord.
Pardon, Mr. A. Roy. It's an application. Read section 19. Challenging order dated 28/05/5. Just family court number in FC criminal case number 420. Issue notice to be sold as submitted by Mr. Roy that the Senate principal judge had passed the order directing the present petitioner to pay this time the maintenance of the child without considering the assessment liability which has been filed by the parties. From the assessment liabilities filed by the respondent herself reveals that she is also rupees and that she has also shown the expenses towards the child rupees 7,000. However, the petitioner is ready to pay the monthly maintenance, interim maintenance to her this child, but as he is only earning rupees 10,000 per month, this his part to pay rupees 9,000 per month towards maintenance of the child. The pay for stay of order dated 28/05/2025 done considering the submission made by he is directed to pay rupees 6,000 per month till the disposal of the child. Estimate accordingly 4 weeks as well. Okay, you will pay now 6,000 per month.
My lord,
6,000 per month till
my lord,
disposal
can it be 5,000? Otherwise, my lord, right now I am receiving 8,000 because of this loan.
need to take any food and all, remain starving and
Make please the lordship. Here, my lord, we have challenged the criminal proceedings, my lord, as well as the order of framing charge against the petitioner, my lord. Only in respect of the petitioner. Now, may I invite your lordship to page 12, my lord, that is the FIR. Here, my lord, nobody has been named, my lord. Nobody has been named, my lord. Here, nobody has been named. It's the FIR, my lord, regarding the, my lord, the commission of a rape in a minor girl, my lord, a minor girl.
who committed rape on?
Oh, my lord, page 39, my lord. Page 39, my lord. Page 39. Lordship may kindly turn to page 39, my lord. This is a part of the charge sheet, my lord. Page 39. May I read, my lord? Page 39.
Yes.
My lord. During investigation, it came to light that 3 numbers of boys of so-and-so village were moving with a motorcycle at the time of commission of crime. Immediately, the IO
PW 59 engaged the source to identify the culprit. In the meantime, VTP member Saddam Hussein informed IO PW so-and-so that his brother PW so-and-so, namely Farooq Ahmed Chaudhry, saw 3 suspects at around so-and-so time just after the incident in the motorcycle having altercation with PW 27 and while passing him. The 3 persons were, these were the 3 persons, Tafajjul Islam, Faridul Islam, and Golab Hussain Malad. These were the 3 persons where Malad alleged to have been committed the crime. And Tafajjul Malad, he has been taken to the PO Malad, and the PO he has been finally tried to escape. Malad, it is that he was killed Malad. The main accused Tafajjul. And Malad, these 2 were on jail. They were subsequently released on bail Malad. Now Malad, now the Lordship may kindly turn to page 41, my lord. Page 41, my lord, paragraph 11. This is the allegation against me, my lord. At the outset, I have to say, my lord, that I am a scrap dealer, my lord. I'll show, my lord, I am a scrap dealer. Page serial number 11, page 41. During investigation, one of the vital material exhibit of the case, is motorcycle of the accused Faridul Islam, was sought for, and the same could be found in a dismantled condition from the possession of the brother-in-law of Faridul Islam, namely Atabur Rahman of so-and-so Gaon under Moirabari PS. Pertinent to mention here that the accused Faridul gave it to him for destroying in the vital piece of evidence the crime after the arrest of Tafajjul Islam. Ownership of the vehicle by Faridul Islam could be ascertained by, but this is the allegation is that Malad, he helped in dismantling the motorcycle which has been driven by the main accused and the other 2 accused persons. Now, Lordship may kindly turn to the, we have or charge framing order to page 56, my lord. Page 56, my lord. The relevant portion, page 60. Well, here, my lord, charges are framed against me, my lord, under section 6 and 17 of the POCSO Act, my lord, against the other persons also, but under in the middle paragraph, my lord, under 6 and 17 Act against the accused Atabur Rahman is framed, my lord. So we have filed a petition for discharge, my lord. It was not favorably considered, and 6 and 17 of the POCSO Act has been added against me. And my lord, I have annexed the deposition of the alleged victim girl also, my lord, page 62. She has clearly stated in the paragraph that she does not know me, my lord. Page 62 is the deposition of the PW1 month. And IO, my lord, in his cross, my lord, he has stated that I am a scrap dealer, my lord. So 6 and 17 of the POCSO may not be attracted against me, my lord.
Yes, is whatever.
Yes, your lordship may kindly, my lord, come to my lord, page number 60. Yes, the honorable trial court has my lord finding materials against the accused persons rightly framed charges under section 238 and 35 of the BNS, my lord. And against other accused persons, yes, my lord, against 6 and 17 of the POSCO Act. Your lordship may kindly come to my lord regarding the kindly come to page 39, my lord. First, your lordship may kindly come to paragraph 8 of his.
Against him, what are the section accordingly from which charge?
Uh,
Here,
to-
under section 61 to so and so, so and so. Read with section 6 of the POCO as against accused persons, Faridul Islam, Gulab Singh.
Yes, they are the
Then-
main
And
accused
then under
person.
section 238.35 BNS as against accused
Yes,
person named
238
Faridul and
causing
Kab-
disappearance of evidence of offense or giving false information to screen offender.
No,
238.
it's okay. And under section 6 and 17 against accused Akabur Rahman. Your name is what is it?
Atabur Rahman, my lord.
Two sets of it was filed or what? Just go through this record.
Yes, my lord. Atabur against Atabur upon 617 of the POSCO Act is also there.
Also there.
POSCO is also there. And my lord, from the materials available, how these accused persons, while the victim, my lord, minor girl, my lord, while he was, my lord, while she was coming to his home after, my lord, tuition, my lord, these accused person even in fact in an alcoholic condition, the vehicle which was used at the time of commission of the offense, and your lordship, this is the person, the present petitioner is the persons who is the brother-in-law of the one of the accused, my lord. He, in fact, in his petition, he stated that he is a scrap dealer, but he is fully aware that these accused persons are involved in commission of the offense, and thereafter, my lord, on being instructed by all these accused persons, he in fact, my lord, dismantled the entire, my lord, dismantled the vehicle, motorcycle used in the commission of the offense, my lord. So it,
It's 617 is there in.
But 17 is
directly
abatement.
6.
yes.
6 is my lord, may not be, my lord. 17 also cannot be there, my lord, because 6 is pen, my lord.
235, 238 and 35 of the BNS and 617, 6 and 17 of the BNS.
Yes, because of the abatement, most probably 617 is there.
Yes, yes, 6, 7.
6 and 17 cannot be there, my lord.
No, 17, 617, not exactly 6. Against 6, there are other persons. For
No,
example,
my lord, against, my lord, Lottie may kindly see, my lord. Page, yes.
no, against you,
Page 60.
238, 35 and 617.
6/17, my lord.
Yes,
Of the
6/17.
6 cannot be there, my lord, against me, my lord.
No, 6/17.
Yes.
Not 6, 617.
6 as well as section 17.
17.
617. 617 means then earlier, suppose 376, 511. What do you mean by 376, 511? Suppose that one attempt, that is 511. This is the abatement, that is 670, not 670 against you. So now see, it is a POCSO case. At this stage, we cannot pass any order on that. Rather, neither.
Otherwise, my lord, from
state
the materials, otherwise, my lord, from the materials available on record, my lord, at this stage, my lord, my prayer before lordship, this is even not a case, my lord, to allow to, my lord, continual, this petition is liable to be dismissed. Because, my lord, from the materials available on record, my lord, Planet Trial Court has rightly framed charges against the accused persons. My lord, he is the person, my lord, who is involved. Although, my lord, he is directly not involved in the offense, my lord, he is one of the prime, can be said to be a prime accused. He is well aware about that all these
And
accused
immediately
person
he
has.
wants to disappear the evidence.
Yes, my lord. And one of the accused is his brother-in-law, my lord.
Yes, obviously.
And
issuing
from the,
notice
my
in
lord,
the states.
description, from the type of offense, how this accused person has committed, it's, my lord, very serious. my
Very
lord.
serious
Very
offense.
serious.
But the offense is serious, but
And in this type of offense, my lord, this type of petition, my prayer before lordship liable to be dismissed.
my lord, but
At this
POCSO
stage, my lord.
but
Otherwise, unnecessarily.
POCSO cannot be attracted against me, my lord, may not be, my lord. POCSO, my lord. Regarding 238.
I'm saying not
And at this
6. I'm
stage,
saying
only, my lord.
617 is there, not 6. Not directly 6. 617 is there. Part Mr. SM of done a conflict of the report. The done it. Action special box case number 179 arising out of PS case number 162 of 61 2 126 2 137 2 74 70 109 238 of NSS Baby section 6 is submit issue and the against setting aside portion and also to set aside the order of cognizance, an order of charge framed against present present petition. To issue notice to the respondents to speed post and issue proper notices required to the state. For the effect post. Also, for this can copy the DCL from the case diary. Estimate after 3 weeks as an date to be placed, or immediately after receipt of the scan copy after service of notice, but it will go through that process.
Malad, one prayer, Malad, the informant, Malad, he is a police officer, Malad. So, Malad, my learned friend may accept no notice, Malad, on behalf of him. Police officer. Police officer.
Who is the police officer?
My informant, Malad.
Informant?
Now, Malad, he has been transferred to some, possibly to the.
No, although informant is a police officer, but here in this case, he's a
police officer. No, police officer.
So otherwise, my lord, he has to make victim a party, my lord.
Yes. Victim
Because,
or
yes, victim or guardian of the victim. Otherwise, my lord, without only here, if informant is the police officer, my lord.
Informant is the father mother, but informant is the police officer.
Police officer.
Yes.
Oh, then to know.
So, my lord, he has to make victim has to be made a party, my lord.
So and so. Pardon. It is directed, the petition is hereby directed to make
Victim or a
victim
guardian of the victim.
Guardian, with father, mother, be the respondent. Please matter accordingly after 2 weeks. 2 weeks as well. We will fixing it to you.
I'm obliged, man.
May I please your lordship?
Yes.
This is an application for seeking modification of on condition of modification of improvement order passed by the session judge Karbi Anglong.
Yes. What are the conditions?
For the condition, lordship. The lordship kindly see the relevant portion of the judgment, page number 21, lordship.
21.
That's one condition for modification for one condition, lordship.
Yes, yes. Which condition? Which condition you want? Bank guarantee.
Bank guarantee, lordship. Yes.
This is a case of this cattle.
Cattle, lordship.
Now see, my personal view
Lying,
is
lordship, lying for long time, for 1 year.
my personal view is a bit different. If your case is pending before this court, my personal view is that bank guarantee is a proper order. So not to proceed with this case before this court.
Lordship, lots of cases has modified this.
I am not going.
Lordship.
We are going by the statute.
Lordship.
This court generally we are going by the statute only. Statute.
Lordship.
Not by the other. Definitely, it may be referred to any. Full court or somewhere. I don't know. For the reference may be there, but at this stage, my view is a bit different. So we'll go by this statute. So may not be sit with this case.
Yes.
Please go it. Please the matter. When it can be listed?
Shape 6th.
6th of March is the matter. 6th of March. কাম কৰিব মই একো লিখা নাই as the 60 এই রেকর্ড আপনি রাখক ক্রিমিনাল 12 নম্বর কেস 12 নম্বর কেস রেজিস্ট্রি অফ লিকুইড 60 without meeting the actual reason when it partly we will make a request before you raise it to list any other batch. Yes.
Yeah, I'm challenging two order, my lord.
One is order. To
Is 35.
page 35. Page 35. Or magistrate order.
35 magistrate order.
Yes, madam. Yes, 35 magistrate order. Complainant, namely Borun Kumar Shah, is present along with learned counsel. Third complaint as well learned counsel. Peruse the materials and record. The instant complaint had filed under section 318, 316, 336, bring for forwarding the case to Dhubri police station under 175(3) of BNSS. However, after considering the materials and record, after hearing the complaint side, we clearly that court dispute present case is absolutely civil in nature. Moreover, the complaint side has failed to show any false document under section so and so for the purpose of cheating the complainant. In addition to this fact, as revealed from the materials record, also do not attract the increasing the offense of 318(4) of BNSS. Further, even though the complainant has filed the instant case with a PR for forwarding the Dhubri PS, the complainant has failed to submit the appropriate affidavit which is required as per judgment of so and so. Considering the above facts, I deem it fit to dismiss the complaint. Accordingly, instant case is disposed of. After the my lord, he filed a revision application before the learned session judge. Session judge also taking the same view that we cannot forward upholding the order passed by the learned magistrate, saying that the dispute is civil in nature. So your prayer for register the complaint, FIR or directly the investigating officer should not be granted and the revision petition stand dismissed. My question is that, my lord, 14, 14, my complaint is that, my lord, in fact, in nutshell, I'm telling you, actually the petitioner mother has 5 sisters. So the mother have made a power, has executed power in favor of one of her sister, Anuruddha Shah. After that, subsequently it was revoked. But Anuruddha Shah, taking advantage of that power attorney, gifted his share of property of her mother, petitioner mother, to her son and daughter. So gifted her property to his son, to her son, and sold the another property to the mother. So this is kind of cheating. This is total cheating because it's a property of subsequently revoked. So this thing, we have filed an FIR before the police station to register the case, to investigate the complainant. So this is the thing. The police just remain silent. So we have written to the Superior Police. Superior Police also didn't take any action. So we went to CGM court. The CGM court power is something limited. He cannot write for the first and the day. He cannot determine what is the materials on record, but how he can say it is civil in nature. At least direct the investigating officer to register the complaint and see what is the facts. This is my submission, man. Simple submission. The rest of the matter be revert back to the learned CGM magistrate, directing the police to raise. I'm not make any prayer for register the FIR. I'm just making them to direct the police whether investigate the case, see whether their prima facie there is a cheating elements or not. So at the very first stage, how can you say that there is no civil in nature? Because I say one judgment I can rely on, manner. If a lordship goes through judgment, you can find this very interesting judgment. Similar case. Yes, this is a case. 2007 SCC online, Allahabad 1533. Para 8, if you have to go through para 8, it is based on the Supreme Court decision, judgment, apex court judgment. Relying upon the aforesaid law as laid down, but you have to actually go through para 8. Relying upon the laid by the apex court, it has been observed by this court in case of Mansumi versus State of UP. Thus, whenever the magistrate is approached by an aggrieved person with a prayer that the police had refused to register the FIR or cognizant offense,
The magistrate is required to look into such affair only to determine as to whether any cognizant offence is disclosed thereby or not. And if he does not, he is no opinion but to direct the police to register the affair and investigate the offence. At this stage, it may point out that magistrate is not required to conduct an inquiry under section 156 of the code. He should not saddle himself with the additional burden of discharging the function of police as a crime prevention and crime detection. It is a primary and foremost duty of the letter as so as we must be left to the police to perform this part of the duty. Therefore, the observation by this court is based on the above two judgments of FS court, as well as the law laid down by Privy Council so. At the stage of directing the police to register FIR cognizant offence by the magistrate under section 160 CRPC, the defense of malafide, unnaturality, or improbability of allegation labeled as wholly irrelevant. These are all matters of investigation to be undertaken subsequently by the police. It is not for it to investigate those defense, but as to this is concerned, he has not to dwell upon that, so he has mandated him to not to. Further, one cognizant offence is described in the application under section 156 CRPC. Defense of malafide, unutility, improbability, relay gets into background of this aspect cannot be taken recourse to refuse registration of FIR by the magistrate. Those magistrates who refuse to direct registration of FIR cognizant offence on such reasoning clout, the law laid down by the Apex Court referred to above, and their order are illegal and pari incuriam, as all courts in India are bound by the law laid down by the Apex Court. My lord, here this says that simple. That it is clear that it is not a magistrate cannot cannot perform the duty of police officer. Let the matter be sent to police. Let them see whether the cheating is there or not. Because cheating elements is 100% there in the FIR. So let the director be given to the police to register the FIR or to investigate. And if it is say there is a cognizant offence, then let the matter FIR be registered. I'm not taking that code.
In fact, there is not a single ground to invoke the jurisdiction of the 528 BNS. Learned trial for concurrent findings of the my lord, learned trial, my lord, CJM code. Your lordship may kindly peruse page 35. In first, my lord, the complainant failed to show any forged document, my lord. Moreover, the complainant side has failed to show any forged document under section 336(3) of the BNS used for the purpose of cheating the complainant. In addition to this, the facts as revealed from the materials on record also do not attract the ingredients of offense under section 3184 of BNS. Further, even though the complainant has filed the instant case with a prayer for forwarding this case to Dhubri PS under section so and so, but the complainant has failed to submit appropriate affidavit. So, my complaint is also not supported by any affidavit, which is required as per judgment of Honorable Supreme Court in Priyanka Srivastava. So, my lord, Court of the Judicial Magistrate, my lord, rightly, my lord, rejected the petition complaint filed by the petitioner. Thereafter, my lord, learned session, the criminal revision, my lord, which was in fact, my lord, order passed by the learned CJM, my lord, affirmed by the learned session court, my lord. And this is purely a civil nature, my lord, rightly held by the my lord revisional court also. This is purely case of purely a civil nature, so there is no infirmity in the order passed by the my lord learned CJM, my lord. So, my lord, this is not a case for invoking the jurisdiction of the 528 BNS. My lord.
So, my lord, my submission is that, my lord, how can the magistrate at the very first stage, sitting at his chair, very first day, determine it is civil in nature? I'm not asking whether it is civil or criminal. What is my prayer in my complaint petition? You just direct the police to investigate the matter. Because it is a duty. It is a when superintendent police refuse to act.
Well, to act as this post office or as a
yes, we can approach them there.
Why the company magistrate cannot apply his mind also while reducing this 173 or
normally it is
normal. It is normal, but it is in this case he has seen everything. Is there any reason for transferring or sending the case record before the concerned police station for investigation?
Yes.
When he found that there is nothing in the record, as in there is no evidence, no affidavit, no documents at all.
No. Documents document we will produce at the time of evidence, not at the initial stage.
Supporting you did not file anything.
And
So
not,
on what basis?
moreover, the complaint side has
said
sent so many false document. It's not false document.
Yes, false document. It's only your submission on the verbal, suppose verbal or whatever.
Yes, my lord.
On what basis the court
Let
pass
them,
the
let my submission, let the matter be remand back, let them, the CGM said.
without anything? How
Yes,
can
yes,
the matter be
let
remanded?
my client will produce,
has
at
to
that time, the client will produce the document.
Huh?
If your lordship given a direction to the magistrate to register.
There has to something.
What is the harm, my lord? If your lordship pass an order, even direct the CGM, to direct the police to register the.
How can the order?
My lord, if there is no ground at all, my lord, why this honorable court will, my lord, invoke the jurisdiction of the 528 BNS?
Yes. Suppose why it is there, if there is any irregularity or whatever committed by the learned trial court, in that case we can change. But the question is that there is nothing.
And their prima facie, there is ingredients, my lord. I'm cheating. I'm written all this thing in the.
Best do one thing. We can call for this TCR, but the recording is there. Or for any.
Yes.
That
Yes,
can be
yes.
at best that can be. Otherwise, there is no
Yes,
case
yes,
at
yes.
all
Yes,
against you.
yes, but
There is no case.
that will suffice.
Report. For setting aside and quashing of the order dated 30/10/2025, passed by learned session judge Dhupre in criminal division number 20 of the 2025. Whereby the order passed by the learned GMFC is upheld and upheld, refusing, denying to direct the officer in charge police station to investigate into the matter. Next, issue notice to the notice to the respondents. However, no formal notice is required to be served. State respondent. Copy of the petition will be served. Call for the TCR. TCR of Twitter TCR.
CR case of 530 now 24.
Petition number 20 of 2023. Are it to say?
D. Bijbura, Judicial Magistrate. First class to be.
It will say CR 539 of
Public 24. First class to be. Executive Magistrate, Judicial Magistrate.
Series to be including PST matter according to 4 weeks. Okay, we are calling for the TCR.
Yes, ma'am. That will.
May I please, Your Lord? Quashing of the impugn order dated 16/7/2024 and 14/11/2024 passed by the learned executive magistrate Chief Chakraborty. Petitioner stand.
Two orders are there.
Lordship. 16/7/2024 and 14/11/2024. As per report of the police, Lordship, 16/7/2024 proceeding was drawn up under section 164 and 165 BNS Act, Lordship. Page given, page given, page 2, 26, annexure C1. Lordship, kindly see the annexure C1, Lordship.
8.
Page, Lordship, 26, Lordship.
Yes. This is the order dated?
Order dated, Lordship, 16/7/2024, Lordship.
Yes.
On basis of the said order, Lordship, learned executive magistrate, Lordship, also pass an order, attachment order against the petitioner, Lordship, 14/11/2024, Lordship.
So there you were the second party.
Yes, Lordship. Lordship, on relying on the judgment of the Supreme Court, Lordship, in this attachment, and also, Lordship, quashing of the petition, Lordship.
Is there any civil dispute?
Yes, Lordship, it is purely civil dispute, Lordship.
No. Civil dispute is okay. Any case has been filed by any party? Yeah, no.
No.
Civil case?
I have already filed against the Lordship 164 and 165 before the
Learned additional session judge lordship. Criminal revision petition lordship. That revision will also dismiss of the said learned court below lordship. And he also, learned court below also finding that paragraph lordship 10 lordship,
So
annexure
when is
lordship
the order
F1.
of criminal revision is 17-1.
Yes, lordship. Is dismissed lordship.
Have you annexed the order here?
Yes, lordship. Annexure F1 lordship, 44 page lordship. In the said order lordship, paragraph 10, learned additional judge also stated that lordship. Kindly see lordship, paragraph 10 of the said order lordship, page 50 lordship. Law is well settled that proceeding under section 164 and 165 BNS are punitive in nature, and the magistrate concerned has the jurisdiction to determine the question of possession, to pass an order of attachment of the dispute land so as to prevent breach of peace. For determining the question of possession, the magistrate is only required to make an inquiry in the present proceeding, though the order sheet of the case record has not been properly maintained. But from the impugned order, it clearly reflects that the learned magistrate has made the necessary inquiry to determine as to which party was in possession of the land by giving chance to the opposite party to produce his document in support of his possession. The magistrate in such proceeding does not adjudicate the right title of the dispute land, which only a civil court has the right to decide, and that the magistrate in such proceeding is only required to decide the possession summarily in favor of one party or other until the question of right title and possession is decided by an appropriate civil court lordship. The learned magistrate in present proceeding has only decided the issue of possession summarily in favor of the first party after making an inquiry, after considering the fact that the present petition, the opposite party in this case failed to produce any document in support of his possession, while on the other hand, the possession of first party has been supported by the report of the circle officer lord.
Why you are agreed? So nicely written order is there.
Lordship.
Yes.
Lordship, it is violation. Executive magistrate have no any power to decide the possession, right, title, and interest in the
Never. Right title to cannot be.
lordship. Lordship, I am standing in I am standing residential house in therein. I also live in there with connection with electricity bill lordship. Annexa C, Annexa E lordship. Electricity bill is also annexed there with the petition lordship.
So now you agree with the order of attachment.
Yes, lordship.
But the revision in court has discussed it in detail, in fact.
Yes, ma'am.
Every aspect, because inquiry was made by the magistrate.
No
One
inquiry.
No,
Lordship.
you are saying no inquiry, but I'm not on that, but as part of the order of the division in
Lordship,
court,
lordship.
the inquiry was made by the learned the magistrate.
Lordship.
Before passing an order, and it saw and
Lordship.
found that first party is in position, so it was in declared position. Right
Lordship,
at the
I am the
interest-
possession, lordship.
Oh, you are saying, I don't know. Now their view is that you are not in position, they are in position, so accordingly, the order was passed for
Lordship.
attachment also. Before passing the order, one inquiry was also made by
Lordship.
the magistrate.
Lordship.
So right that interest, so definitely it cannot be determined in a.
Lordship, I am studying in the dwelling house there on lordship. How can
why
executive
did
magistrate
you,
pass the
approach
attachment
in
order,
civil
lordship?
court? You could have
Lordship,
approached a civil forum in that case. You have the right and the interest over the position. Or
lordship, kindly see our judgment, lordship. I have also given you, lordship. Lordship.
Yes, Botakuri.
Otherwise, my lord, he has not challenged the revision petition, my lord. Regarding that revision petition, my lord, already, my lord, regarding after passing of those orders, my lord, already he has filed a revision petition, and revision petition has specifically stated that learned executive magistrate has not touched about the right title and interest of the.
Yes.
Yes.
Never touch.
And thereafter, now he has again challenged the order which was already, my lord, subject matter of the criminal revision petition, my lord. Already in the criminal revision petition, my lord, all those orders were already challenged by him. And now he will have to challenge the revision
Yes,
petition
you
also.
are challenging that order also, magistrate order. Now.
No, Lordship. Executive magistrate order, I have challenged it, Lordship.
Now.
Yes, Lord.
How?
Because he has
Lordship,
already-
executive magistrate illegally passed the order against me, Lordship.
No, already revision is there, na?
Already,
You have to challenge the revision of court order only.
I am quashing, Lordship, I am approached before this court quashing for the impugn order, Lordship.
Which order?
Executive magistrate order, Lordship. Learned executive magistrate order 16/7/2020.
But you have not challenged the criminal revision order.
Earlier already I have challenged it, Lordship.
No, I am not on there.
Lordship.
You have challenged the order of the magistrate before the revisional court, that is the session judge, additional session judge.
Lordship.
So, but at this stage, you are not challenging the order of revisional court.
Yes, Lordship.
No.
No, Lordship. I
Not
have
challenging.
challenged the order of the executive magistrate.
How you can come here now?
Lordship.
কথা বলতে কোন আইনি?
revision को already हे order था against the
ওসে কিংবা
time number. He revisional order to cleanse. Let him go for the my lord case again. Let pass over.
Lordship. No, divisional order to close question. It is coming challenge the High Court.
You make an amendment, prayer amendment, every amendment you make up, or rather you can withdraw this petition with a liberty to file a petition. If anything is there, you can. Your entire petition cannot be entertained at this stage.
Lordship.
You are challenging on one hand the order of the magistrate, on the other hand the revision is already there, but you are not challenging the revision order, because revision order, what revision order? Or the revision order upheld the order of so and so.
Lordship.
So you have come before this court against the revision order.
Lordship.
You have not challenged the revision order.
Lordship.
Then how can you now interfere with the order of the magistrate now?
Lordship.
If suppose revision is allowed, dismissed, or we allow the revision order of the revision, dismiss the revision. If it is dismissed, in that case, that may not be upheld. Or may not be upheld, whatever.
Yes.
But now you have not challenged anything.
Yes.
You have to withdraw this one, I think, because entire petition has to be otherwise respective.
Yes.
Okay.
Lordship.
And if any this, you have only certified copy is there. There's no any document otherwise. You can withdraw liberty to fail up because some formal defects are there.
Lordship.
Same order, my lord, he has already filed revision petition and again against the same
That's what
order.
I'm saying.
Earlier order, Lordship, I have not inserted the section.
Cannot. Heard Mr. P.K. Gogoi. You, Mr. Gogoi, na?
Yes, Lord.
Heard Mr. P.K. Gogoi. After hearing the petition, the length is submitted by Mr. Gogoi that there is some formal defect in the petition and accordingly paid for withdrawal of the same with a liberty to file a petition, to which Mr. Botapur raised no objection. In view of this, the petition is disposed of on withdrawal with a liberty to file a fresh. It's
Highly obliged.
May it please your lordship.
Yes.
Lordship, I am challenging the order dated 23/7/2025 passed by the Principal Judge Family Court 1 Lordship. Lordship, here in this case, the order may kindly, order is at page 45 Lordship. Here, the present petitioner, he being the opposite party Lordship, he received notice, then he entered appearance. Then Lordship, one preliminary objection was filed because one case is pending there in Shillong Lordship, a divorce suit and a case of maintenance filed by the present respondent Lordship.
In Shillong?
Before, yes, Shillong Lordship. Thereafter, the litigation is going on there, Lordship. In the year 2024, Lordship, this notice has been received by the present petitioner, Lordship. Then he appeared before the court, Lordship, filing a preliminary objection on the maintainability of the maintenance case, Lordship. But even after that, the court heard the matter and categorically they have, the court denied that, okay, this can be taken up. So it proceeded, Lordship. Then it was
in Shillong, you're saying one divorce and one maintenance.
Maintenance case is pending, Lordship.
Pending before Shillong.
Yes, before Shillong. But the divorce case is filed by the present petitioner, their Lordship.
against the
That is also
respondent.
pending in Shillong.
It is pending till date. Today also it is pending, Lordship. Then in the meantime, she filed this there. She filed a maintenance case there also. But subsequently, in 2019, she filed there. Then she stopped appearing in this case, Lordship. Then this 24, it is filed here. So on the
But
ground
is there
of
any order of dismissal or anything in the 2019?
nothing. It is
Well,
still
as per
pending,
record,
Lordship.
it is still pending.
It is still pending, Lordship. Evidence and everything, as I came to know, Lordship, the respondent, that means the present respondent, she did not appear there, Lordship. After 24, now she again started appearing there, Lordship, and this is pending. But this present, that means the FC criminal case is, it went on, Lordship, before the court here in Gauhati. The preliminary objection has not been considered by the Honorable Court, Lordship, below. Then
Where is the order?
By order, Lordship. The order I have not annexed, but I have mentioned it here in the para, Lordship. Lordship, in page 7, paragraph 8. That the petitioner begs to state that after filing preliminary objection, the family court 1 Kamrup Metro fixed the next date for adjudication on 21/5/2024, and both parties were heard by the learned counsel on the ground of maintainability. The learned court, after hearing the parties, passed the order on the same date, and it was observed by the court in its order that the operating portion I have mentioned, Lordship, there is no bar in seeking maintenance by the wife under different statutes. Then it is held that this instant case is maintainable. This was the observation.
Is it a DV case or maintenance? Is it a case of earlier 125?
Lordship.
And in Shillong also?
No, in Shillong, it is under section 36 of the family code. Yes, Lordship. 36 and 37 of the
family code.
Yes.
For maintenance.
For maintenance, Lordship. Then, Lordship, it went for, and the petitioner filed the written statement also along with the preliminary objection. So the matter proceeded, Lordship. It was fixed for counseling, Lordship. In one date, the petitioner could not manage because he comes from Bangalore, Lordship. He could not manage leave, so he could not come. Then subsequently, he fell ill, Lordship. I have annexed the medical documents, and he was hospitalized also. He underwent operation also during the pendency of this case, Lordship. Subsequently, the matter proceeded ex parte, and on 23/7, Lordship, the matter was finally heard and decided, Lordship. The judgment was passed, which is page 49. 45. Lordship, here in the petition, the present respondent, she made various allegations, even the names of certain women who are also that means mentioned there without making the person party, Lordship. So this has also been taken in that while passing the judgment, Lordship. But the operating portion is that, Lordship, if your Lordship kindly peruse page 51, Lordship.
Yes.
Considering the standard of living of the sites, the petitioner deserves a monthly maintenance of rupees 15,000 and her minor son 5,000. Lordship, we have categorically stated that she is a principal in a school, Lordship. She is earning. So the present petitioner, he has no objection in maintaining his son, Lordship. But the wife, she is earning and she is capable to maintain herself. And that apart, Lordship, initially the present petitioner, he used to pay, but he was repeatedly been deprived of visiting his son, Lordship. And the conduct of the respondent, Lordship, kindly mentioned, which I have here mentioned in the petition, she has changed the title of the son from Barua to Basumatari. This also she has done, which I have mentioned in paragraph 4, Lordship. Page 6 is there. So the attitude of the respondent, Lordship, this can be gauged by her conduct, Lordship. So my humble prayer is that the present petitioner, though he is earning, but the amount that has been mentioned in the petition has been denied by the present petitioner, Lordship. by filing the written statement. But even though Lordship, this has been considered, and that apart, Lordship, the court has mentioned that regarding the the present respondent, she filed her these things, Lordship, liabilities also, but no bank statement has been taken into consideration, Lordship, which is very important to consider the while granting maintenance, Lordship. So the quantum, Lordship, the petitioner, he is duty bound to his son, Lordship. This has to. He has no objection to that. But the 15,000 that has been granted to the respondent, Lordship, this has not been taken into consideration. This Rajesh and Neha case, which is held by the Supreme Court.
Principal means which in is a government school, government college?
No, Lordship, this is a private concern. This is a private concern,
And what
Lordship.
is your IA for?
So I
IA
am
is for?
Lordship.
IA is for?
IA is for Lordship. The execution case is going on. So I'm praying for the stay of the execution, Lordship. That's why I filed a separate petition, Lordship. And this is, Lordship, I pray for the setting aside of the order because this has not been properly, that means taken into consideration all the facts, Lordship, and the petitioner, as he was suffering from certain ailments, Lordship, and he was hospitalized and operated. So he and he is a chronic patient even, Lordship, heart patient and high BP, Lordship. That also I have attached the recent these things, Lordship. So I pray before your Lordship that the notice be issued to the party and the present execution that in the IA, Lordship. This IA may kindly be stayed, Lordship, till the disposal of this case, Lordship.
This is an application under section 528 of the NSS. Proceeding as certain portion of which has been in order to 2307 passed by Principal Judge Family Court number 1, Kamrup N. In FC Criminal Case number 46 of the section 125 CRPC. Issue notice to the respondents, sole respondent to speed post and energy process, and also call for the DCL. Full stop. Further, it is submitted. Further, it is submitted by MS, researching that initially at the time of filing this present petition under section 125 CRPC before the court of Principal Judge Family Court number 1, Kamrup Metro, the petitioner appeared and raised the preliminary objection, stating that raising the issue that the petition is not maintainable as the one DV case as well as one maintenance under the Family Courts Act is already pending before the court of Shillong. Learned Court of Shillong, the court of Shillong. But without considering this aspect, it was held by the principal judge that the petition is maintainable. However, due to his illness and as he undergone some operation, he could not appear before the learned principal judge, and the order was passed ex parte, whereby the petitioner is directed to pay maintenance to the respondent to the tune of rupees 15,000 per month, and for her son rupees 5,000 month. She further submitted that the petitioner is not at a stage for paying such amount of maintenance at this time. Moreover, the respondent herself is discharging her duty as a principal in a private school, but that was not considered by the learned principal judge. In view of this, she submitted that the execution of operation of the judgment in order dated 2307 may be stayed till the disposal of the present petition. Considering this submission made by learned counsel for both sides, the petitioner is hereby directed to pay rupees 10,000 per month till the next date of listing. Listing matter accordingly after 4 weeks as on the date to be raised. I order the is for suspension of delivery.
Execution.
Tate Anisri,
61 of 2025, Lordship.
Because card MS, the Sachi and application. This is an application praying for stay of the execution, criminal execution case number 61 of the 2025, arising out of FC criminal case number 46 of 2024, and pray for stay of the execution of judgment and order dated 23/10/7/2020, as discussed in criminal petition number 262/2026. The petitioner is hereby directed to pay rupees 10,000 per month till next date of listing, till the next date of
Lordship.
list the both the matters accordingly after 4 weeks as on the date to be.
Lordship, will he be paying to the family court or here in the registry, Lordship? Family court, Lordship.
The maintenance will be deposited before the family court. Family court principal.
As he has today, I am saying also, as he is not, he has stated also, he has no direct contact. He has not done anything, any agreement with that person. His statement is there also. So, if there is any kind of transaction in between them within that period of time when these materials were seized, in that case also his involvement may be there also. And today, that is why I am praying for some more time, at least 1 week or not more than 10 also, so that I can collect the CDR. And if there is anything, then I can enlighten Lordship that whether there is any involvement or his involvement is there or not. Lordship, not. Because Lordship, as on that Lordship, only because of the statement of the driver from whom those materials were seized, from the owner.
What the driver says.
Driver says that Lordship, that he has not said anything about that. I've loaded the material from the logistic that transport company, and I do not know what is there in the cartoons.
But is there any statement that he received some of the instructions from the owner?
No, there is nothing, Lordship. That is why, Lordship, because Lordship, and this is nothing but this is a Zimma petition. This is not the bail petition that he is in the bail. So Lordship, only 1 week time, Lordship may kindly allow me. If there is nothing, CD, I will also say that there is nothing I have not found. If there is something, then Lordship will see whether that is a part of his involvement or not, Lordship. Only 1 week time, Lordship, I pay for that, Lordship. Because Lordship, NDBS substance commercial quantity is involved. And I thought.
My lord, CDR, as my learned friend has said, CDR, what he'll find? I have called up my driver. I can anyway call up my driver. Today, where are you?
That is true, Lordship.
They won't get the
connection. That is I am not saying. I'm not doing the point. Regarding driver connection, because he is the driver, there may be some contact that has to be, that will be a contact between all the time. But if there is a contact to this person, this manager, the person who is from Tripura, this person is also this owner has some contact, then we can say some contact is, because he has stated in his 180 statement that he has no contact with them. The driver is making the contact. So Lordship, let us see, Lordship, whether there is anything comes out. So 1 week time, Lordship, if nothing comes, then he will get the benefit of.
Yes, Barasaji, you waited for how many? Your
From October.
vehicle is in custody of
October.
police since when?
1710.
1710. Okay, November, December, Jan, Feb. Late
4 months.
for 4 months already gone.
1 week time, Lordship.
Now that is the only ingredients which have to be seen. Whether there was any knowledge, any intention, anything was on the part of the owner for that.
If it
that
is
delivery and
something Lordship, what happened, Lordship, if it is materials are being theft by stolen materials, then in some cases I can say today itself, Lordship, there is no any involvement. But this is as we all know, he may not be involved. I am not saying he is involved, but he may not involved. But now it is an organized crime. All have been done in a plain manner. So if something comes on, because driver may not say, as driver has not says nothing, owner has no, the logistic company has not say, as on that nothing said, nothing comes up from here. But let us check that CDR if nothing comes.
This time again your name is not there.
My lord, actually my signature was not while filing, they had filed it, but she's there.
So, no, on the last occasion, we recorded the name of Mr. J. Kumar.
J. Kaur. My lord, he is in another matter.
Achha, anyway, now whose name? Her
C.
name
Kalita.
is-
C.
C.
Kal-
See, Kali.
T. Kalita.
Yes.
MST Kalita. But your name is also not there. Anyway, MST Kalita.
C. Kalita, my lord.
C. Kalita. You are appearing on behalf of, suppose J.
J.
Kumar.
Kaur. J. Kaur.
On behalf of J.
10 থেকে 11 দেখলো
Also had
Dos.
yes from Planet itself. appearing on behalf.
11 নম্বর 10 এ। Ah, no, 10
And at the request, we will be learned petition. Let the matter be listed
on 10th
10th of March.
we'll
May not be exactly 5 months, maybe 4.5 months.
we'll send back the order. We'll retain the
Keep
city.
it because for passing the order, I may also require, no? CD.
We'll
let
retain the
it be-
CD.
Let it be written. CD be written. CD, your CD I have received, no? CD along with the report, along with the CD be written till next set of listing. List on 10th of March.
And one direction may be given to the IO, so I can bring one direction one report from the IO whether his involvement is somehow connected with this person. Whether IO has found any connection with this person, because if that comes,
That should not
Materials has to be there, not a report, my lord.
Ah.
That way, material has to come.
Material has to come.
Obliged.
May I please, your lordship? Lordship,
Yes.
kindly adjourn the matter for the day, lordship.
For the day.
My senior is some
You are
hurdle, say
Miss-
that's why he's not.
You are MSA Google.
A, lordship.
You are.
Yes. Senior name is not reflected in the cause list.
The request made by MSA Google to learn counsel for the petitioner. That raised adjourned. However, scanned copy of the TCR has already been received. List the matter accordingly. After one
Sorted,
week,
lordship, sorted.
short date with.
also an interim.
On
Interim
two,
is there.
two, March 2.
Oh, interim was there.
Interim is there,
Oh, if interim is there, then it's.
My lord.
Eh?
last part of March.
That's-
Third week of March. Third week.
Sorry, third week.
My lord.
16, 17, 20, open.
18th.
18th of March.
Obliged, lordship. Pale in the interim may continue.
Interim be continued with it.
Sorry.
Yes, what about 22?
Let's
Scan
scan copy.
Scan copy.
Can copy receipt, lordship. Charge has been framed, Sessions Tribal case, lordship. Charge has been framed on 4/2. 4/2 was a date fixed for 4/2 for consideration of charge. On that that date charge has been framed, lordship.
4/2.
4/2. Now, lordship, there are two petitioners. Petition number 1 is the son, petition number 2 is the mother. Woman, lordship. It is entire based upon circumstantial evidence. I have annexed the charge sheet, lordship. If lordship may kindly take up page 31. There is allegations the mother wanted to save the son, so she made initially she made some confession to
Under which
police.
section case is registered?
Lordship 103.
103.
103.
103 is there. At least mother, if mother can be considered. I also understand this.
Where from you are saying to save the son?
Page 31, Lordship.
Where from?
Page 31.
Yes, yes.
Page
which line?
31, the second paragraph. During investigation of the case,
Hmm.
the PO was visited and rough sketch map of the PO was drawn. The complainant was examined and record her statement under section record 180 BNSS and 183 BNSS. Judicial statement is also recorded. The witness were examined and seized the suspected murder weapon, one petticoat sari from the place of occurrence, and the dead body was inquest done by the executive magistrate, and the body was sent to SMC Silchar for PM examination. During PM examination, one sharp blade was recovered from the cloth of the deceased, which was preserved by the doctor and sent to me along with one vial contains 2 ml of blood of the deceased, and all these are sent to
Directorate of Forensic Science Laboratory, Gauhati, Kailipara for forensic examination. In the course of investigation, the accused person, Aparna, admit that she has killed her daughter-in-law and took all allegation upon her. But later on, after proper interrogation, she has denied the commission of offense and revealed the name of his son, Shayan Pal and Aman Pal. Accordingly, he was apprehended, and during investigation, he has admitted to me and narrated the whole story before me and was arrested and taken under police. Thereafter, this charge sheet was filed.
Since when she is in custody?
Since 11/8, Lordship.
Hmm?
11/8,
11/8/2025.
25.
So evidence is not yet recorded. Where is the FIR in fact?
FIR is page 16, Lordship. You can typed copy as a page 16. It is by mother of the deceased. If I may read, Lordship. Page 16. I beg to state that my daughter Pompita was married to Sanipal. Sanipal is not the accused. He is in Bangalore.
Outside.
So the other accused person is the brother-in-law of the deceased. A son of the aforesaid accused number 1. About 18 months ago, after her marriage, while she was residing at her husband's house, her husband and the aforesaid accused persons used severely torture her physically and mentally. My daughter used to tell us over phone. About 8-9 months ago, my daughter's husband, the son of the accused number 1, went to Bangalore for work, leaving her at home. After that, the accused persons used to torture my daughter more severely. My daughter used to tell us about the said matter over the phone. My daughter was tolerating this cruelty, considering her future. Yesterday, on 9/8/2025, at about 3 p.m., the accused person number 2 suddenly called me over phone and asked me to come to their house. As the accused person suddenly asked to come to their house, we contacted with my daughter's husband, and he also told to come immediately. Accordingly, we left our home, and on reaching the house of the accused persons, learned that my daughter was lying in throat slit with sharp weapon and dead condition inside the house of the accused persons. Thereafter, when she was taken outside, I saw cut injury with sharp weapon in her throat. All the accused persons confining my daughter inside their house brutally and mercilessly murdered, giving sharp blow in her throat with sharp weapon.
Now, what about the other accused persons?
He is the son in this.
No, the other accused persons mentioned in the FIR.
Other accused person is the petitioner number 1.
No, this is petition number 1. As per the FIR, I'm saying.
Oh, as per
One
the
is
FIR, this is petition number 2. Other accused person is this petitioner 2. Petitioner number 1, Lordship.
No, I can understand. I'm asking.
Against other, there is nothing. Nibas Pal,
Was not filed.
No.
Oh,
These 2 persons were arrested.
Only.
2 only arrested, and charge sheet has been filed against these 2 persons.
My lord, here I have gone through the record, my lord. But although my colleague said that my lord, the search was framed, my lord, but that order is not available in our report. First of all, my lord, the last order was 8/1/26, where it was committed to the session judge, my lord, and 21/1/26 was for appearance before the my lord, that up to date on the record, my lord. And regarding the involvement, my lord, what happened, my lord? Sister-in-law was brutally killed by the my lord, the present petitioner number 2, my petitioner number 1, my lord, with a blade, my lord. There is some quarrel or that is altercation, my lord. Thereafter, he is murdered, my lord. From the statement, it reveals, my lord. And from the statement, it also reveals that, my lord, there is always altercation, my lord, quarrel among themselves, my lord. As the husband is outside the my lord state, my lord, all of them, my lord, there is some assaulting or cruelty is there, quarrel, altercation is always there in the house, my lord, as per statement of the witness, my lord. On that day, there is some altercation, my lord. Thereafter, he has committed the offense, my lord, and brutally killed the my lord. This is, my lord. And even she is married only for 1.5 years, my lord. 1.5 years she was time for marriage, my lord. And search film, I do not have any knowledge about,
because we moved it on first on 6/2. Thereafter, TCR was called for on that day. It should be there in the TCR.
not there.
Only 8/1/26 that,
8-1, I have also annexed, I think.
that is 21/1 for appearance, that up to that, dear my lord, in the record, my lord.
21-1, 2020.
For this, after commitment 21.
My lord, that,
then,
my lord.
charge may be framed, I don't know.
Charge, date was fixed on 4/2/4 charge. And my instruction of the charge has been framed on 4/2.
Charge has been framed.
Yes, before we moved the bail application. On
My-
6/2, it was the motion on 6/2.
My lord, here, I have the objection in such type of heinous offense, my lord, brutally killed the, my lord. This is my lord. And at this stage, I have the objection for granting bail, both of them, my lord. Initially, mother, my lord, she said that I have killed her, my daughter-in-law, my lord. But after interrogation, it was said that, my lord, to save her son, my lord, she has categorically said this statement, my lord. Thereafter, my lord, accused person also, my lord, petitioner number 1, my lord, he has admitted his guilt, my lord. He said that I have killed her, my lord. And that is my submission, my lord, not at this stage, my lord. Charge is already framed, my lord. And at least, my lord, material witnesses may be examined, my lord. It is heinous offense, my lord, brutally killed my daughter-in-law, my lord. That is my submission.
At least, Lordship, petitioner number 2, mother may be considered because entered investigation on circumstantial evidence. There is no eyewitness on circumstantial evidence. They have to explain in due course of the trial. They will appear before the trial court.
See book has to be done in council for the petition. And also have Mr. Sharma did done it in an application, a section students, connection with students. Scan copy of the TCR along with the case share to receive. Next one, it is submitted by Mr. Bukast that the present two petitioners are innocent and they have not committed any such offense as alleged in the entire case is based on some circumstantial evidence. And evidence was admittedly the victim died out of injuries sustained by her on the sharp injuries sustained by her on the neck. But these petitioners are not involved in the alleged offense. We further submitted that in the inquiry also it has come to the light that the petitioner number 2, who is the mother-in-law of the victim as well as the mother of the petitioner number 1, only admitted her guilt to save her son, that is the petitioner number 1 of the offense. It's further submitted that being a lady, her matter may be considered at this stage. However, she is ready and willing to appear and contest the case by appearing in the trial court below on each and every date to be fixed by court. Next one, Mr. Sharma. The learned edition is submitted in this regard. That there is oh no, I got a line for variety of Mr. The forecaster further submitted that the charge has already been framed against these two petitioners on 4/2/2026 prior to filing of the present bail.
We filed earlier, it was listed on thereafter. We filed earlier. It's listed.
Next, Mr. Sharma, the learned additional PP submitted in this regard that there are sufficient materials against these two accused petitioners, and there are also materials available from decision that they used to inflict mental and physical torture on the deceased, and on the date of incident, she was brutally killed. However, he submitted that initially the guilt was admitted by the petitioner number 2, who is the mother of the petitioner number 1, but subsequently during investigation, it has come to light that out of the quarrel, it is the petitioner number 1 who killed the victim, but deceased. But he submitted that till date no evidence is recorded, and hence there is probability of tampering with the eyewitnesses or other evidences of evidences of the PW, and accordingly, he raised objection in allowing the petitions to go on bail at this stage. Next. Hearing the submission made by non-passing proposals. In considering all other circumstances of this case, this court of the opinion that petitioner number 2, namely so and so, may be allowed to go on bail. Allowed to go on bail at this stage. However, therefore, the petition number 1, namely so and so, is not considered at this stage. Accordingly, so and so is provided. This whose satisfaction? This week?
Kachar, Session Judge Kachar.
Silchar, Kachar Silchar. Kachar Silchar is there or now? Oh,
Kachar Silchar, Karimganj is Sribhumi. Kachar
Karimganj is
Karimganj Sribhumi.
as on of prayer to allow people.
My lord, only to the petition number 2.
I'm deeply obliged to.
My lord.
23.
May I please? TCR was called for, my lord. TCR perhaps
TCR
has come, my lord. The
Yes.
16 witness, my lord. Out of 16, 7 have been examined, my lord.
Out of how many witnesses?
7 have been examined, my lord. Out of 16, my lord.
16. 1-6.
1-6,
1-6.
my lord. 7 have been examined, my lord.
1-6. 7 examined.
My lord. 302, my lord. 2 persons were killed, my lord. One wife and daughter,
Wife and daughter were killed.
my lord. Page 23, the PW1, my lord. Married, my lord.
Who is he? He is anyway related with the.
Yes, related,
Yes.
my lord. Married, my lord.
Bail application of what is his ground for seeking bail, that is first discussed also, because
Hmm.
going to the
These are
entire
P-
witnesses
PWs
also.
and all. Now, why you need bill?
It's a very serious case, my lord. Only my prayer is, my lord, is the local person, my lord. He faced with child, my lord. At present, my lord, he considered his prayer, my lord, granting bail, my lord, because last 2 years he is in jail, my lord. Any condition, my lord, he will face trial, my lord. And evidence stage is going on, my lord.
Last 2 years.
2 years, my lord. From 9/4/2024, my lord. More 1 year and 10 months, my lord.
Is there any vital witnesses are yet to be examined by the court? You have said 7 witnesses examined
My
out
lord.
of 16. Who are those? One is the independent witness I have seen, and the rest are?
Next, my lord. Page 26, daughter, my lord.
One of the
If-
daughter.
One of the daughter of the accused person, my lord.
She is the eyewitness.
My lord. And page 28, my lord. Father of the accused person, my lord. In prose, my lord, father says, I do not know how Mamata Mallo died in her home.
So he brutally killed his wife and daughter, no?
Very brutally, Lordship.
Now going out, what he will do now? See, eyewitnesses are there, their own children.
Yes, yes, that's right, madam. That's correct, madam.
His father may do not say support the case because he is the father of the accused. No, he is the father-in-law of the deceased, but he is the father of the accused. Yes, law for it.
This is very dangerous if this type of persons come out from the jail, Lordship, and as all the witnesses are not yet been examined, and there are some other witnesses also, Lordship, who is required to be examined, and apart from that, Lordship, whether there is a scope of chance of acquittal, Lordship. Because, Lordship, for consideration of bail, Lordship will see, Lordship, whether there is a scope of acquittal. If there is no any scope of acquittal, then he may jump about a bail also, Lordship. So there are all these possibilities are also there. And when there is a offense of such brutally murder, Lordship, when his 8 years, probably 8 years or 5 years daughter is being killed, and wife, everyone is lost. Even one daughter is also would have also killed, but subsequently she somehow
she
fled away. So, Lordship, at this stage, Lordship, this type of person should not be come out. His bail may not be regulated. He should not be under Lordship.
PW2, my lord, says, I personally has not seen the occurrence. Daughter of the accused.
Maybe, may not. He saw the dead body, you know. And
Even,
is there any
independent witness
explanation
said,
from your side? Your
Ye-
presence, the
Yes.
two persons died in your house,
Yes.
in your courtyard, lying
Yes,
in such a condition. Is there any explanation from your side under most probably 106 or whatever the evidence act? If there is no at all. Anyway, we can, it is admitted that he is behind the person's a considerable period. But what to do?
For this type of weapon, that may not be counted, Lord.
Only when he is a local person, my lord,
Only because
imposing
the
any
CS
terms and condition, my lord.
What
Only
to
because
do
the
if he
CS
fled
spent
away
some
with
time,
all the terms and condition, with all terms and condition, if he fled away, then what to do? Anyway, heard Mr. A.K. Azad, the learned counsel for the petitioner, and also heard Mr. P.S. Lawford, the learned petitioner, on behalf of state responsibility. This is an application under section so and so in connection with so and so scheme copy of this is the against copy of the case record along with this received by the DC. It is submitted by Mr. Azad, the representative petitioner. He is in custody since last 9/4/2024 and till date he is more than 1 year, 10 months in custody. And that apart, out of 16 numbers of cited witnesses, the prosecution has already examined 7 numbers of witnesses, including the vital oblique eyewitnesses. The accused petitioner is the local person and he will appear and hence there is no chance of absconding. Rather, he will appear before the learned session judge on each and every date to be fixed by the court. He further submitted that some of the witnesses have not seen the offense and they also cannot be considered as vital witnesses to the prosecution. He is ready to abide by all terms and conditions if he is released on bail. Next pardon, Mr. Lawford, in an additional PP submitted this that it is a very serious nature of offense wherein the allegation is against the petitioner that he killed his wife and daughter by inflicting injury within the full stop. Further, he submitted that his own daughter and some of the eyewitnesses have fully implicated the present petitioner and also described as to how the incident had happened. Further submitted that it is a case of very dangerous in nature, wherein the accused petitioner and thus there is every probability of the hampering or tampering with the evidences of other witnesses which are yet to be examined by the prosecution, and that apart, the probability of absconding the accused petitioner also cannot be denied at this stage. as there are sufficient materials against the present petition, which may end it with a conviction. Mr. Lockwood accordingly raised an objection and submitted that till the recording of some of the vital witnesses, he may not be released on bail. And in the same time, he also submitted that the length of detention cannot be the sole ground for considering bail application, wherein the offense is wherein the offense is serious in nature, and that apart, it is the allegation that he killed his own wife and government. Hearing the submission made by an constitutional process and also paid the case rate and some of the evidences recorded by the prosecution. It is the fact that some of the eyewitnesses, especially the daughter of the accused, also deposed, wherein she described and cleared the entire incident. And some of the vital witnesses are yet to be examined by the prosecution. Considering this aspect of the matter, next previous nature of serious nature of the case, vis-a-vis the probability of funding of the accused petition. This court is of opinion that bail cannot be considered at this stage. Hence, rejected. Your petition stands rejected at this stage.
May I please? Lord?
Yes.
Lordship.
You have received the
My
scan.
lord, scan comparison.
The informant lodged the FIR alleging that on the day of occurrence, she was sleeping in her rented house. The accused person forcefully entered her rented house, threatened her throwing a knife, and committed rape. Your Honor. My humble submission before Your Honor on two grounds, Your Honor. Number one, the police submitted the charge sheet without FSL report, Your Honor. Without
She is a
FSL.
married lady.
Married.
What FSL you
My
know?
lord, required my lord.
Not required. Yes, then
If required, then I have seized the submission, Lordship. My argument on merit is that medical report, Your Honor. Your Honor may peruse medical report, page 22. Peruse, Your Honor. Column 14, Your Honor.
yes.
May I read? Call his case history, Your Honor.
Not there is that.
Anyway, what do you want to submit from here?
Here, the lady was a divorcee. As per history, lady was a divorcee since last 5 years, Your Honor. Then, Your Honor may peruse page 24, Your Honor. Opinion of the doctor, Your Honor. Nowhere it is mentioned that there is any symptom of rape or sexual intercourse, Your Honor. So, my humble submission before Your Honor is that this honorable court in Ranjit Hazarika versus State of Assam
When she went for medical examination?
on the same day, Your Honor.
Same day.
Same day. Page 22, Your Honor.
Page?
22.
No,
Well-
whatever. I'll just ask you on the same day.
Of course.
Since when he is in custody?
1911, 2025, Your Honor.
What is the stage of the case?
Just committed, Your Honor.
As per my last order, my lord, 9/2/26, it was committed to the session court, my lord, and next day is section 23rd 2. Already over.
Evidence is fixed on 23.
2. It is already
Oh.
day before yesterday.
As per you, any evidence is recorded, especially the victim?
I have
No,
no.
SARS not yet.
Search yet
It is
to
only
yet to
committed.
frame, sir.
Only committed.
May I know from my learned friend when the FSL report was submitted before the learned court below trial court, Your Honor?
I don't know. Is it?
My lord, here I have come to the record, my lord. Here, Lordship rightly pointed out, my lord, she was a married woman, my lord. That is why perhaps medical report it will come at the time of trial, my lord. Whether it is consistent or not, my lord. But 183 statement, my lord, she has categorically stated that he has said in night, he came to her house, my lord, said that he is nothing to live here for night, my lord. And as he is known to him, my lord, he is given one room, my lord, to live in there for only, stay only for the night, my lord. But on that pretext, he has taken the advantage, my lord, as nowhere is there in the house, my lord. He has taken the knife, my lord, and at 12, my lord, he went there, my lord, and committed the offense, my lord. On the, my lord, taking the knife, my lord, in his hand, my lord. And one important thing is that, my lord, after that hue and cry, my lord, at 12, my lord, all of the neighboring came here, my lord. And he fled out. But all of the neighbors started searching him, my lord, at night, my lord, so that he can be apprehended, my lord. But he fled away, my lord, at night, my lord. From that statement of the witnesses, my lord, and other 183, my lord, and my lord, from the witnesses, my lord, it reveals that he has committed the offense, my lord. And in her statement 183, he has said that forcefully committed the offense, my lord. And therefore he fled away. But after that, he has hue and cry, my lord, but all of them came, my lord, together, my lord, and searched him in different places, but he had fled away, my lord.
So it is not a case that no one has come.
My lord.
All of them come.
My lord, all of them searched him, my lord. And 183, my lord, in my lord, some of the cases, my lord, when someone came there, my lord, so that seen him, thereafter filed the FIR in some of the cases. But here, after committing, my lord, and at the pretext of knife, my lord, she has hue and cry, the other persons came at night 12, my lord, and all of them searched, my lord, where he went there. But he has fled away. But he's in, from there, it reveals that his involvement is there, my lord. And charge is yet to be framed, my lord. Victim is yet to be examined, my lord. Let him remain for some days, my lord, and after examining the victim at least, my lord, lordship may consider. Yes.
May I submit, Your Honor? Lordship, in paragraph 12, I have stated on record, Your Honor, that I was a president and I have filed a election petition before the Borbeta, being election petition number 3425 against on Nur Farida Begum, Your Honor. His husband, Nur Jalal, is residing at Hatigor Sariali, Your Honor. And she have done all this conspiracy because, moreover, I have stated in my petition para 13 that I have never seen the lady. I could not recognize the lady. But therefore, Your Honor, may if peruse the charge sheet and the list of witnesses, these are from the area of the Sheikh Nur Farida, against whom I have lodged the election petition, Your Honor. So there is
Nur
a
Farida? She is Nur Farida. Victim is Nur Farida?
no, Your Honor. Against whom I have filed the election petition at Borpeta, Your Honor.
So you want to say that by with the conspiracy with this Nur Farida, she lost the FIR. For political rivalry.
Lordship. Her husband is the owner of a scrap shop at Hatigarh Sariali, Lordship. And he resides there, and these witnesses are managed by the husband of the Sheikh Nur Farida Begum, Your Honor. If Your Honor,
These are your submission. Okay, I can
yes,
understand.
and if Your Lordship peruse the short list of witnesses. Then
You
it
said
is
all belong to that locality.
address of the, yes, Your Honor.
No, these are your submission, I can
Yes,
understand.
yes. So,
But
Your
what
Honor,
to do, okay, very serious allegations are there, and that sometimes it happens. We have seen many cases wherein
yes,
it says that in absence of her husband, someone came, raped her. She made after some time she made hue and cry, and then in the morning she informed about the incident. These things are there, some suspicions are there. But here I don't know. But as per the fire at the night about 12 p.m., 12 noon or wherever, she made a hue and cry, and all the persons, neighboring persons came and made a search on for him.
oh,
So that is there. Otherwise, I can understand your submission. There may be some political liability.
is a
that
very
would deny
reputed
it.
person, Your Honor. Two
Let
times
us see, the charge
elected.
is also not framed till
Two
date.
times elected. One time was president of a GP, Your Honor. It is not possible, probably.
Everything is possible. For GP,
So,
everything is possible.
in one case,
It
Your
is
Honor,
possible.
against the same person, in one case, Hatigao PS case, similar type of offense, another case was registered. The learned session court already granted bail, Your Honor.
Have you moved any application before the learned session judge?
Yes, Your Honor.
Rejected.
Rejected. I have annexed. So I am ready to face the trial, Your Honor, at
Okay,
any
yes.
condition, Your Honor. Already in one case, I granted bail, Your Honor.
At least pick maybe example.
Mr. S.H. Rahman, the learned petition. And also heard Mr. B. Sharma, the learned additional people on behalf of citizens. This is an application, section so and so in connection with scan copy of the CD, scan copy of the KCR and the CD receipt, page receipt. It is submitted by Mr. Rahman, the present counsel for the petition, that he is innocent and has not committed any such offense as alleged in the FIR. It is the case is filed with conspiracy by conspiracy. No, in a conspiracy with one Noor Farida, who has some political rivalry against with the present petition, and on her conspiracy only, the FIR was lost by the alleged victim. No such incident had happened the night of incident. That apart, the medical evidence also does not support the case of the prosecution. He further submitted that accused petitioner is in custody since 1911-2025, and hence, considering his period of detention, also his prayer may be considered. He will regularly appear before the learned trial court below and will contest the case as and when the case is fixed for, as and when the case is fixed for. Next paragraph, Mr. Das, the learned edition PP submitted in this regard that there are sufficient debating materials against the present petitioner, and more particularly on the night of incident itself, she made human cry, wherein all the nearby people gathered there and they made search of the petitioner, who fled away from the place of occurrence. He further submitted that the case is very recent and only on 23/2/2026, no, only 9/2/2026, the case was committed. The date of appearance on 23/2/2026. Mr. Sharma accordingly submitted that till the recording of evidence of the victim, this prayer may not be considered at this stage, as there may be every possibility of tampering or tampering with the evidence of the witness's spirituality victim. Next para, hearing the submission made by the counsel for both sides, I have also failed to take this report. First statement under section 183 BNSS and under metricity this diet. It is seen that the serious nature of allegation is brought against the present petitioner on the conclusion when effects, and hence I find that the recording of the statement of the victim, the prayer for bail, Pendant the prayer may be considered after recording of the Milai report, after recording of the evidence of the victim, as victim statement is not yet recorded in that part. The charge is also not framed against the present petitioner. However, the next part, however, the learned session judge is hereby directed to proceed with the case to record the statement of the witnesses, especially the victim, within a reasonable period, preferably within 1/2 months. 1/2 months. With the observation above, it will find it fit case to extend the privilege of bail at distance and hence same statute. This is 1-2 months later, just giving an opportunity to the learned trial court below. If cannot be recorded, that may be.
It's 1 and 2 months.
Absolutely, 1/2 months with a reasonable period, hard statement, minimum hard statement is required.
Obligation, Honor.
26.
Yes, 26, what is the?
My lord, here charge sheet submitted, my lord.
Charge sheet already submitted.
Submitted, my lord.
Are you on interim?
Earlier, they were in interim.
If you are interim, then we are extending your interim for 15 days.
My Lord, it may be made absolute in terms of the recent decision of the Honorable Supreme Court. I'll just take your lordship to that, my Lord. So far, the 438 concern, it is not for a temporary period. It is till the end of the trial. My Lord, that has been explained. My Lord, your lordship is aware, right from the Gurbakh Singh, then the Sushila Agarwal. And this is the very recent one, passed on 9/2/2026. Lord, I'd like to read this. It's a very wonderful decision, my Lord. Right from paragraph 4 onwards, I will read. It appears from the materials on record that the first information report bearing number so-and-so came to be registered with the so-and-so district Kanpur, state of Uttar Pradesh for the offense punishable under section 82-85 of BNS, that is dowry death, my lord, and section 3 and 4 respectively of the Dowry Prohibition Act. Now, my lord, I will take your lordship to para 10. The High Court, while granting anticipatory bail, passed very unusual, your lordship kindly see the word, unusual order, which reads thus: the present criminal miscellaneous anticipatory bail application has been filed on behalf of the applicant Shumit in so-and-so under section so-and-so, District Kanpur, seeking anticipatory bail with a prayer that in case of arrest, the applicant may be released on bail. Then, my lord, I will not trouble your lordship. Then, your lordship, come in the next page, paragraph 5. It may be stated that in the case of Shidaram Shatligappa Mehra versus so-and-so, it has been held by the Honorable Supreme Court that while adjudicating on an anticipatory bail application, the court must consider the nature and gravity of the charges, the possibility of the accused fleeing the judicial process, and that the court must carefully evaluate all the material available against the accused and also consider the actual role of the accused. In the present case, having regard to the settled principles of law relating to anticipatory bail and having regard to the submission of learned counsels for the parties, the nature of the allegations, the role of the applicant, and all the facts and circumstances of the case, the prayer for anticipatory bail is liable to be allowed without any further consideration of the merits of the case. Accordingly, the anticipatory bail application is allowed. In case of arrest, para 7, your lordship kindly see, the flaw lies here only. In case of arrest of the applicant involved in the above case, crime number, he will be released on anticipatory bail till the filing of the police charge sheet. My lord, it is against the statute on furnishing personal bonds so and so and true sureties. Then, my lord, your lordship kindly see in the next page, paragraph 11. A plain reading of the order referred to above would indicate that the anticipatory bail was granted by the High Court as prayed for, but the same was limited only up to filing of the charge sheet. Once the charge sheet was filed,
The protection earlier granted came to an end, and in such circumstances, the appellant once again prayed for anticipatory bail by way of fresh application, which came to be rejected by the High Court. We fail to understand what is the idea in restricting the grant of anticipatory bail up to the stage of completion of investigation and filing of the charge sheet. Either the court may grant anticipated bail or may decline. However, once having exercised its discretion in favor of the accused upon consideration of the overall matter, there was no good reason for the High Court to restrict it up to the stage of filing of the charge sheet. Then I will take your lordships to, my lord, position of law from paragraph 16. In Bharat, Chaudhary and another versus so-and-so, this court held that there is no restriction in section 438 CRPC to grant anticipated bail, even when charge sheet has been filed and cognizance is taken. The relevant part of the said decision reads as thus. From the perusal of this part of section 438 CRPC, we find no restriction in regard to exercise of these power in a suitable case, either by the Court of Session, High Court, or this court, even when cognizance is taken or a charge sheet is filed. The object of section 438 is to prevent undue harassment of the accused persons by pre-trial arrest and detention. The fact that a court has either taken cognizance of the complaint or the investigating agency has filed a charge sheet should not by itself, in our opinion, prevent the court's concerned for granting anticipated bail in appropriate cases. The gravity of the offense.
See, here in this case, I can understand. It was
Well-
the earlier order of the High Court. It was there the case that the anticipated bail was granted till filing of the charge sheet.
My lord.
Obviously, till filing of the charge sheet was there. But here in this case, I don't know. The interim was
My lord,
granted
there is
without
a-
resolution.
Now, your lordship, can we
Only
see here?
considering the submission made by you or from the other circumstances. So at this stage, he is saying that the case has already been charged. Either we can grant you for further interim protection may be granted for 15, 20 or even for 1 month, or we may call for the case diary and all. Then only we can see whether
My lord,
his
better.
cooperation was there, whether his any custodial interrogation was required at that point of time. These are the things to be considered.
My lord, in that
Now-
case, my lord, let your lordship call for the record, because your lordship kindly see, your lordship called for the record on 24/7/2025.
24.
It came many occasions, 24/7/2025. In so many dates it came, sometimes they say cases come, but we want to update it. Now, in this manner, it went up to 27/1/2026. My lord, it is the fault, my lord, I will say, on the part of the prosecution.
Now see, definitely part of the first
So
prosecution.
it is,
was
and
disagreeing
your
with
lordship will find it's not that grievous type of case. My lord, it's a fight between the husband and wife. And my lord,
Yeah.
there was a scuffle, and she was in a kitchen. The husband went there. He was scolding his baby. Then she came from the kitchen, and there was a scuffle, and the knife touched certain areas of the neck. Now, this way is not that is not an there is no antecedent. Then she was convicted earlier. There was a criminal antecedent. There is nothing of that sort. Therefore,
Okay, in that
Look-
case, if you see that in that case, definitely there is a lapse of the prosecution side. They could not produce the case diary on many occasions.
they produced
that
many a
can-
times.
For this,
but-
my lord, up-to-date CD was also called
Up-to-date
for, my
is
lord.
really up-to-date
Sometimes
CD was
injury
not
report
there.
also not available.
But do you have any information whether at this stage you have shown as an absconder in the charge sheet or
Custodial interrogation all over.
no, whether you have shown as an absconder there? No.
No, not at all. And the grounds, my lord, no such that she will be fleeing from justice and all that. There is no such thing. And my lord, these decision, just your lordship, I wanted to read the entirety, but that has said what is the position of law. Merely because charge sheet has been filed, it doesn't mean I have to go and appear there and that court will grant bail. Even the, my lord, this
Now,
one of
see,
the
the
court.
question is that when charge sheet is filed, definitely the trial court has some jurisdiction over that case. So in that case, we generally don't want to make any order in that regard. But obviously, we extended the interim. But if you say that yes, there are some details, then we can call for the entire scan copy of the case diary along with the case record. Then
No.
only your matter can be considered. Otherwise, at this stage, we don't have anything. Whether what was your conduct, whether you have cooperated, whether
My lord,
you-
I feel, my
No.
lord, your lordship is very right. Your lordship kindly can call the scan copy of the Otherwise, what will happen? Our bitter experience in the trial court, the moment the lady will appear, they will not give bail. This is my bitter experience. I have seen so many cases. So therefore, this decision has squarely said, Melody, in such circumstances, what the High Court or Session Court can do. Well, there is no impediment that since because the charge sheet has been filed, you will have to go there invariably. Well, that position has been deprecated by the Supreme Court.
Yes, yes, I have seen.
So therefore, I can take your lordship to those paragraphs where the Supreme Court is utterly deprecated for the
Okay,
conduct
we'll
of
see
the.
to it then let your scan copy of the case diary and the subpages, because at this stage we don't have anything before.
Your lordship is very right.
That's what.
Very right.
That's what only. It can maybe considered. I won't
Mine.
say that it may not be considered, but it can be. Otherwise, part Mr. S. Dutta, Lieutenant Senior Advocate, assisted by Mr. S. Dutta. Will name prior to your name, or Musa Hadi is there or not? She gone.
Or her name can be recorded.
Senior Counsel S. Dutta, as assisted by yes. K. Bora, MS K. Bora for the petition, and also heard Mr. B. Sharma, the learned additional BP appearing on the application. Stop it. This case was fixed for case date, but it is submitted by Mr. Sharma. The case has already been charged against the present petition.
Charge sheet
Case number
I charge sheet number 395 of 25. Dated 31/12.
13
31/12. 20.
31/12/20. In that context, Mr. Dr. Leonard Senior Advocate, relying on the decision of Apex Court, recent decision of Honorable Apex Court, first in case of in criminal appeal on 9/2/2026, arising out SLP criminal 1536/2026, has submitted that it is the view of the Apex Court that anticipatory bail only cannot be considered to be granted till the filing of the charge sheet. View of this, let the scan copy of the TCR along with the case diary be called for. When you can, when it can be
It will come from registimal from Tinsukia.
Tinsukia. Tinsukia plan. Have you received any notice or
Yes, yes.
summon?
We have received date of appearance on 5th March.
But prior to 5th of March, possibly
It will not be possible.
Okay.
And if the bail is, I mean, extended, in that case, she can appear. There is no problem.
In that case, it can be. 12th of March, we are listing.
12th March.
12th of March, when interim be extended till next. Okay, we are extending.
Yes. I'm obliged.
No, I cannot. Notify the judge.
Lordship,
Justice. Yes, what is the position of 28? Yes.
Lordship,
Submit? Yes.
pass over for the time being.
Not possible. Timing is not possible.
Senior, he is in another court.
No, timing is will not be possible. There are many matters. If you can submit, what is the position? Where are
The case diary received, madam.
Case there is. Are you on interim?
Yes, interim is there now.
You are in interim.
Interim.
Then
Your
we
lordship,
can
in the
retain the
petition,
case.
my lord, initially FIR was not there, my lord. Initially one report was.
Yes,
for-
come on. You are on 28? Item number 28, you are?
Lordship.
Oh, okay, then we come. Yes, your honor. Yes.
Immediately lordship. Earlier, FIR was lost. When the case was filed, lordship, the FIR was not lost. Thereafter, I have filed a case without FIR, lordship. Thereafter, case was registered, lordship.
Initially, my lord, a report was called for, my lord, whether any case registered or not, my lord.
Oh, acha.
So FIR was not there in the petition, my lord. So later on, my lord, I came to know that one case was
Yes.
registered. So that FIR is there in the case diary, my
Now FIR is in
Yes,
place.
yes.
And till date, the interim was extended.
Yes.
Now
Yes,
you have
lordship.
received the CD also.
He on interim lordship, he appeared statement accorded, lordship.
Statement of the victim is also there, my lord. 180 BNS, my lord, one
So this is the FIR now.
FIR. my lord.
Acha.
This is the
What is the FIR?
My lord, FIR, she has made lots of allegations, my lord. Initially, my lord, concealing the fact that he is a married person, my lord. Thereafter, my lord, he established, my lord, love relation. Thereafter, my lord, he established physical relationship with the, my lord, victim. And they both were living as husband and wife. And now at the time of filing of the, my lord, of the FIR, she has also alleged that she was pregnant of 4 months. And regarding that, my lord, there are two independent witnesses also. My lord, I have flag mark, my lord, in the apartment in which, my lord, both the accused and the victim persons were lived together. The statement of those independent persons, they stated that, my lord, both the accused and the victim were stayed together in that apartment, my lord, and they introduced themselves as husband and wife. And regarding the medical document, my lord, one note of the IO star mark, my lord, flag mark, I have, that is the note of the IO, my lord. My lord, victim, my lord, intimated the IO that she will provide the medical document, but till now I have not find any medical
Regarding her pregnancy.
pregnancy.
So I'll listen to you. I'll listen. So now, what is her allegation at present? They were staying together as a husband and wife.
Husband and wife.
Concealing her parents.
Now my lord, he avoids.
She's a
He refused
Muslim
to
lady
now
or Hindu lady?
live-in relationship.
No, she's Muslim or Hindu.
Muslim,
Muslim.
what are
Oh,
both?
Muslim. Oh, then
And she's a married lady, lordship.
she's also a married lady.
Married lady, having a
Yes.
son.
She in
lordship.
fact insists for my lord for registering of the marriage, but
Yes,
ultimately
only that allegation, lordship.
That you have not?
now he avoids.
Actually, my lord, she is approaching to register the marriage before the sub-register office. He is avoiding, and that is the allegation, lordships. As per
Now
the
you are ready to accept her.
actually, what are yes, lordships. What are in relation, lordships? They were initially
But I can must say that if she is a wife of another person,
lordships.
her earlier marriage is still in
That
substance.
I do not know, lordship, but she has a child, lordships. She has a child.
She now alleges that the accused person is my lord earlier married. He is a married person by concealing that fact, my lord.
Now he is saying that she is also a married lady.
Yes, both are married,
That, my
lordships.
lord, I am not. There is nothing.
Both are married, lordships, and both are met in a private company or other else, lordship. Thereafter, they introduce themselves and they are love in relation. Thereafter, like that, and actually, what happened? They perform nikah also, lordships. They
Now
perform
she is your wife then?
yes,
She's
lordship.
your wife.
Yes, yes. Yes, and but her allegation is that I am avoiding the register the marriage lordship before the sub-register office, lordship.
She wants to get married.
Yes, lordship. No, she wants to register her marriage, lordship, before the sub-register. Only that allegation, lordship. And my lord,
So
all
registering a marriage, do you have any obligation?
Now allegation is also that, my lord, now the present petitioner, accused person, refused to marry her, my lord.
Oh, achha.
That is the also.
no, my lord, I'll say all the sections are available except section, my lord, 85.
85.
Lordships.
Who does it?
85 is non-bailable.
Yes, 85 is non-bailable. That is, my lord, 498, earlier 498 A,
Oh.
lordship. And others are bailable, lordship. And I already appeared lord statement recorded, lordships.
No, she consider herself to be his wife. If she's
Yes.
not wife, then 498 may not come also. I don't know.
Yes, well, but from the independent witnesses, it reflected that living
They were staying.
together in that apartment. She also, my lord, one nikah was also solemnized between both
Yes.
the parties in presence of, although no one from the family of the, my lord, accused person was there, or family of the victim was also
they
there.
entered.
Some friends were there, my lord.
Yes.
And thereafter, one agreement was also, my lord, executed between the
Performed.
parties for agreement for marriage, my lord. But ultimately, legally, there was no.
Actually, agreement for marriage, we were
Ultimately, they
told
were,
all the notary public also not to
yes.
do these things. Agreement for
Yes.
marriage, agreement for
marriage in-
divorce. What are these in fact?
And nikah already performed.
Regarding
That's why.
that, those documents are not there in the city, my lord. That is the allegation. And regarding the
Anyway,
medical documents,
You want to
also,
submit then? Yes. Yeah, for the informant. We have already filed. Well, I'm saying. It is already tagged with the record, or we'll just check.
she also annexed some medical document in the object.
That I have not received, lord. Objection.
You have not received
No,
your
no. Otherwise, my lord, she married also, bought her living lordships. And then nikah also performed, lordship. Only because of, my lord, not raised,
One written objection has been filed by the informant.
lordship.
You want to get the copy now, or what to do? We don't have time also.
You also may dispose of also, like,
No, you want to submit anything in on behalf of this one? Yes, from the objection, do you want to submit now?
My lord, first thing is that when they have approached to the notary, my lord, for a agreement for marriage, my lord, the victim informant stated that she is a divorcee, my lord. She is married, it is admitted fact, but husband accused concealed the fact that he is already a married person. My lord, first one is that. And thereafter they living as a husband and wife, my lord. And in the meantime, when she come to know that he is already married, then this accused person avoid to meet the victim, my lord, informant. Then the quarrel occurred, my lord, and till that, my lord, the accused is absconding to avoid to meet her, avoid to consult anything, my lord.
Yeah.
And in the meantime, when they live as a husband and wife, she is 4 months, 6 months, my pregnancy. Medical is there, my lord. All medical documents, and it is also reflected that she is pregnant, my lord. And she done abortion on instigation of the petitioner, my lord. Yes, my. This is the fact, my lord.
This time she is still her pregnancy is aborted. This time.
Yes, my lord, aborted, my lord.
Not carrying pregnancy.
Not now it is not
She is
carried,
not
my.
Well, then, my lord, I have to kindly give the copy, lordship, because I have to reply it, lordship. Because my lord friend LS, she has allegation, lordship, against me, lordship. So I have to reply, lordship.
But
Because
if he keeps you now as a wife, do you have any objection?
My lord,
nikah already performed, lordship. So nikah already performed.
Nikah is already performed.
Oh yes, lordship. She has admitted, lordships. Nikah already performed, and their other form is dear, lordship. Forum is there. DBAC is there, my lord. Family court is dear, lordships. If I have not provided any maintenance or other else, lordships. Other forum is dear, lordships. I am not avoiding.
That case, most probably she wants to take it.
my lord, so many quarrels is occurred. My humble submission is that if she goes to the life of the accused person, it is risky, my lord. So their facts comes to the court, my lord, and they are now
why can't we
enemy
receive the
each
copy?
against each
Yes,
other.
my left hand hasn't been provided, Lordship. The other one.
Oh.
I
Have
do
you
not know.
received Botakor, have you received the copy? You have received the objection copy? Copy of here we have file. It is
I have
Yes.
you have not received.
No, Lordship, I have not
Do you receive
received.
any extra copy?
extra copy.
How
one is,
you have
one is here,
no,
my
how
lord,
you have
without
sub-
documents, my lord.
Pardon?
Without
Without
documents, my lord, one is copy.
Kindly fix another that, Lordship. I have to reply that objection, Lordship.
Administration network. Also administrative board internet edition between aforesaid NMSBR legal counsel for the case diary received, but it is submitted by MS Sultana that she has already filed written objection for the informant, but the informant but Mr. Hawk, the learned counsel for the petition submitted that she has not received any copy of the said bail objection filed by the informant, and accordingly she submitted that a copy may be, a direction may be given to the informant respondent to provide a copy of the written objection. In view of this, the petitioner is hereby directed to serve copy to both the state respondent as well as the petitioner side, along with all medical documents annexed annexed with the petition, with the objection.
My lord, the documents what I have submitted filed, my lord, I have not available in. So my friend can inspect the record, my lord. I have only the copy of the, my lord,
Copy.
without documents.
Please to the matter careful. Interim.
Yes, I am.
CD.
CD may be, CD may be updated, Lordship. Medical report,
11 till 11, can you be able to retain the case diary?
yes.
Can it be returned?
Lordships. Yeah, I don't have.
CD be returned according calling for an updated one. It's returned accordingly on 19/3/26. It will be extended till next day. You just provide the copy.
On what that, Lordship?
On 19th of March.
Kindly after 22, Lordship, because I am on fasting. I am deeply obliged.
May please, your lordship, conduct counsel lacks on another code, lordship. Kindly pass the
Time being cannot be. Where you have received the case diary here?
CD receive my. Otherwise, another day.
Are you on interim?
Oh, yes, I am on interim.
You are on interim, na? So can it be retained up to 12th of March?
12 March. My lord.
It will be long.
Your lordship may not pass any order regarding retaining of the CD, my lord. If my lord necessary, I will have to.
Okay, then we were not passing any order.
Simply pass.
Due to the request made by the counsel for the petition. Matter is adjourned. CD is already received. Let the matter be accordingly listed from 12th of March 2026. Interim be continued till next day.
34, my lord, search sheet submitted in this.
Are you on interim there?
Interim.
Yes, CS number. What is
CS
the
number 87/2026, dated 25/1/20.
25/1/26.
Yes.
So we are extending your interim till 15 days
Lordship.
with a direction to appear before the learned trial court below with an appropriate application.
Obliged.
May it please your lordship. It's a pre-arrest bail, my lord. The lordship will find the FIR, my lord, at page 9, my lord. Page 9, my lord.
Page
9, my lord.
9.
May I read, my lord?
Yes.
With due respect, I beg to state that on so and so on Sunday at about 5 p.m. when I was going to Bijli market for marketing, then my mobile phone and Airtel SIM number were stolen. Thereafter, when I went to ATM for withdrawal of money, then I got knowledge that from Union Bank of India, Nagaon branch, so and so, rupees 2,94,000 have in between so and so date, my lord, was transferred from my stolen mobile to different through UPI, my lord. This is the case, my lord. Now, my lord, why the petitioner before your lordship, my lord? Your lordship have a kindly turn to page 17, my lord. Page 17, my lord. Fourth column, my lord. 26/11/25, my lord. An amount of rupees 5,000 has been credited in my account, my lord.
20?
26/11, fourth line, my lord. 1, 2, 3, fourth line, my lord.
1, 3, 4, yes.
Haman Nath, my lord. 5,000 rupees, my lord. This has been credited to my account, my lord. And the FIR was lost by Haman Nath, my lord. FIR was lost by Haman Nath, my lord.
Another Hemannath.
No, same Haman Nath.
Hemannath is the victim and the informant.
Victim come informant, my lord. His phone was stolen, my lord. And from his phone, my lord, 2,94,993 is debited. And out of which 5,000 has been credited to my account.
Credited to your account.
Yes, my lord. That is the case, my lord.
You are Safikul.
Yes, my lord. And your lordship had dealt in this matter, my lord, where the person who inserted the SIM, well, they were arrested, my lord, and they were granted bail subsequently. I don't know how this amount came to me, my lord. 5,000 credited in my account.
Really, my lord, this is a, my lord, all these accused persons is a gang, my lord, operating, my lord, for after stealing the, not only, my lord, stealing the, my lord, after, not only stole away the mobile phone, but also, my lord, somehow, my lord, they collected the UPI, my lord, app of the, my lord, identity number of the informant victim. How they, my lord, these are the, my lord, their modus operandi of all these accused persons, my lord. After, my lord, 23/11, the incident occurred on, my lord, 23/11/25 at about 5 p.m. Thereafter, till 26/11, my lord, total 45 to 50 UPI transactions to different big bank accounts from the, my lord, bank account of the present informant victim to other person's bank account. And the present accused persons, my lord, he is, he is, my lord, Shafiqul Islam. His, my lord, bank statement is also available in the case diary.
I have also next.
Yes. It is his bank account is at SBI Lakshmipur.
5,000.
He's in his account, my lord. Those, my lord, 5,000 amount credited. So he is, my lord, directly involved along with all other accused persons. So immediately after, my lord, getting the mobile number of the victim, my lord, how this person involved in immediately thereafter within 3 days from different bank accounts. They also, in fact, how they collected the UPI ID number, my lord. Regarding all these aspects, my lord, investigation, some of the, my lord, other accused persons yet to be arrested. My lord, investigation is going on. Otherwise, this is a gang, my lord, operating in that, in this manner. They are involved in committing this type of offense.
Well, those two main accused,
And
lordship has
roughly
granted.
custodial interrogation. Yes.
One Abdullah and Esop, my lord, they were granted bail by this court, my lord. They were the main culprit, my lord. Now 5,000 is credited to my account, my lord. Only 5,000.
Question is not only of 5,000, but my lord, this person, accused persons in a gang, how they are operating. So, my lord, yes, he was arrested. His detailed statement, everything was recorded. Thereafter, on the basis of his statement, my lord, later on, my lord, those SIM card which were inserted by one Farooq Abdullah, he was also arrested. Thereafter, my lord, one Sojon, my lord, Isop Ali, Farooq Abdullah, and one Joshan Ali. And thereafter, police, my lord, investigated the entire matter, and these accused for how those total 45 to 50 transactions to different bank accounts from the bank account of the victim. So in this manner, they are involved in continuing this type of.
Another section 318, my lord, is cheating, my lord. My role of cheating, my lord, where comes. And theft, my lord, 303 and 318, my lord. Theft and, my lord, cheating, my lord. Well, I will cooperate with the, my lord, investigating agency, my lord. Custodial interrogation may not be required, my lord.
There are many other accused persons.
And if your lordship, my lord, subject to my lordship, his friend, my lord, lordship may grant me interim, my lord. Let my statement be recorded, my lord. And after 15 days, the case diary may be on the safer side, my lord. I say. Because only 5,000 is credited, my lord. In my account also, someone may send money, my lord.
Question is not only of
If
5,000,
no,
maybe
no,
of
if
1,000, but
no,
a larger gang is involved, because committing this type of offense.
larger gang, my
Because
lord,
totally 45 to 50 transactions to different bank accounts. Though all those persons, my lord, can they say that we are not involved, my lord? How in my account those amounts credited, we do not know. If they do not know, they will get up to, from 5,000, they will get at least, my lord, 1,000, my lord. Suppose, my lord.
That is assumption.
Because of that, my lord,
Assum-
because not assumption, my lord, this type of offenses, my lord, we are continuously dealing with the case there. So from that, my lord, how these persons are involved in this type of offenses. My lord.
From his experience, he is a bit.
And here this
Let me appear before the IO, my lord. Let my statement be recorded, my lord, in the interim, my lord. And if your lordship,
As per the case diary.
Yes.
So who was the mastermind who did this? Is there anything there?
Initially,
Because I had granted one bill, that is his role is his SIM was inserted in somewhere.
Yes.
That much his role.
Yes.
And that part is Farooq. Farooq is the main mastermind.
Isop Ali, Farooq Abdullah, my lord, later on, my lord, during statement while recorded by from because Isop Ali also received some of the amount. One Farooq Abdullah, he later on, my lord, during investigation, he told the my lord deposed before before police that at that point of time his mobile that SIM card was used by Farooq Abdullah or while that transaction occurred, my lord. And thereafter Farooq Abdullah arrested, and thereafter later on Isop Ali also, my lord, changed his, my lord, statement also in some points, my lord. And during all these statement, thereafter bank statement, my lord, collected by the police, and thereafter those from those bank accounts that those transactions reflected, and from the Hemennath, my lord, that those are after collecting those bank statements.
We are on item number which?
36.
It's the application. Submitted by Mr. Yes, no connection with the LS. Whether he cheated any or he is involved in case of to attract case against him in section 3.8, yes. However, it is a fact that this 5,000 was deposited in his bank account through EPI through bank account on 26/11. But till date, he is not aware as to how the said money was entered in his account from the account of the but he is ready and willing to extend his cooperation in further investigation of this case if he is granted with the privilege of the arrest. Next, Mr. Bot, VTP submitted that from 23/11/2025 till 26/11/2025, there are 45 to 50 transactions, PPI transactions from the in the different accounts from the account of the informant and informant. Be further submitted is an organized crime wherein many persons are involved involved and a huge amount of money has been withdrawn from the account of it is an organized crime wherein many persons are involved. And case is still under investigation to know the root of the investigation and investigation and the account verification is still going. He accordingly submitted that the prayer for period may not be considered as case, and if it is granted with the privilege of prayer, there may be chances, even temporary or further investigation. Considering the submission made by the and the materials available in the case, I find that one opportunity will be given to the present petitioner to appear before the investigating officer and to extend his cooperation for the investigation. In view of this, it is provided that healing. Okay, will be under interim protection.
Mine. I'm obliged. I have to appear Malu within
17.
mine. I'm deeply obliged.
19.
My lord, on the 26th of March.
26. Yes, what is 37?
The updated case diary may be called. I will get the. I will return back the case diary in item number 36.
Oh yes, yes. Sorry. Case diary be written. No one appears for the petition. 37. What is 37, Mr. Hari? They are not on interim, I think.
Yes, my lord. In this case, only a report was proposed. Earlier adjourned, my lord. Since 2/2/26, my lord, no one actually, my lord, every on 2/2/26 adjourned, 4/2/26 adjourned.
And they here we need the report.
Yes, yes. But no one appeared till that in the case. Appeared, but my lord, every time, my lord, they took adjournment. And report
What was the first order? Order says nothing. No?
Nothing, my lord. The report was also not called for it. They also no
one appears on the petition. It is also submitted by Mr. What on 3 occasion also they paid for an item and no one had appeared yet. Why it is listed for hearing column? I don't know. No, not there is no order at all.
Yes.
One order, first order, initial order is of 29/01/2026 on the prayer made by Swain's consent of Swain's cases adjourned. List taken on 2/2. 2/2, no one most probably appeared, I don't know. List taken on 4/2. And in 4/2 also, on the prayer made by the petitioner, list the matter on 25.
And so they also not, if they are not interested to pursue the matter, your lordship may.
Let us one more chance given. No one appears. Swain's. Let the matter be accordingly listed on people 12 free so and so. In absence of the petitioner, consequential order will be passed.
49.
Please, Your Honor.
Yes.
Your Honor, report was called for.
CD received here?
Report received, madam. No case has been registered at Mandia Outpost, Bakpur Police Station against Madam Abdul Salam. This report is only against Abdul Salam, but there are 4 petitioners.
Oh. .
However, the matter is under inquiry.
1, 2, 3, 4. 4 petitioners are
Lordship,
We'll
for
have to
petitioner.
get a fresh report.
there. You are Mr.
I Hussain.
Huh?
I Hussain. Interim was there.
Just a second. R. Hussain.
Or
Huh?
I Hussain.
Oh, I. Acha, acha. I took it. I Hussain. Also had Mr. P. Potter. The report received from the police station only on behalf of whose behalf? Abdul Salam.
Abdul
Abdul
Samad,
Salam, petitioner number 1.
is
But
Salam.
no report has been received in connection with the other 3 petitions, that is petition number 2. Let a fresh report be called for from the concerned police station as to whether any case has been registered against all the petitions. Interim be continued till next date of listing. Listing matter accordingly on 13.
Publish.
This may be taken up after sometime 89 years in the like.
So we can admit it. What is there?
Yes.
It is admission only criminal appeal, na? It is against acquittal or conviction.
Petition matter.
Against conviction or
The paper book has not been received as party instruction.
no, whatever. It is against the conviction or what?
Actually, I am not the engaged.
Acha, acha.
Let him appear.
Yes, law for what is it?
We have also not available with the record.
So Darakulla has been appointed as a amicus. We'll record his absence otherwise.
PCR not received yet.
Mr. Obliged. So you have been appointed as an amicus.
Lordship, I have,
It is a case against a conviction.
yes,
order
Lordship, but
conviction.
I'm not getting any documents, Lordship.
Oh,
Direction may be given to the registry to provide me the copy of the memo. Lordship.
PCR not received yet.
PCR is also not received.
That is that.
Copy of the memo of appeal is not there. One petition, this abedon is there only.
Whatever, Lordship.
That is also not provided.
Yes, that is also not.
Heard Mr. Darak, done it. Amicus appointed for the applicant. Heard Mr. B.S. Lockwood, done it additional people appearing on behalf of state. However, it is submitted by Mr. Otto that till date no documents of the papers has been served to him. Though he is appointed as an amicus. Accordingly, the registry is hereby directed to submit the relevant papers, the documents to the learned amicus curie, Mr. Dar. And the registry is also hereby directed to call for the his case TCR. Let the matter be accordingly listed for admission forum. After 2 weeks, after 3 weeks, we'll do. After 3 weeks, as on a date. We have made a direction to provide you what are the copies here.
Yes.
Otherwise, we also don't have any other copies.
TCR has been called for.
Pardon?
TCR has been called for.
Yes, TCR.
Same, Lord. This is also not provided.
Oh.
No. Good.
Same order. Okay, we're listing it after 3 weeks.
Public.
May I
Yes.
please your lordship?
Yes.
My lord, the revision petition is filed, my lord, against the judgment and order passed by learned additional session, thus Gauhati, my lord. In which case, my lord, learned additional session has set aside the order passed by the learned judicial magistrate, my lord, on my lord 24/2/2022, my lord. And after that, my lord, petitioner, I am appearing as legal aid counsel, my lord. Petitioner, my lord, suffered great hardship as my lord set aside the order of the learned lower court. My lord, kindly come to page number 20. Huh? Already, my lord, served notice to respondent number 2 by my lord, according to the office note. Notice served to respondent number 2, my
Notice
lord.
already served.
Yes, my lord. My lord, my humble submission, my lord. My humble submission is this, my lord, pending disposal of this petition, my lord. Kindly, my lord, please to pass an order for my lord, interim order saying and suspending the judgment and order dated, my lord, 18/12/24, because she has no source of income, my lord. She has no parents also. Only younger brother has become the burden of this petitioner, my lord. So my humble submission is this, kindly staying, my lord, in the order of the learned law resistance. This is my humble submission, my lord, till the final disposal of this suit, because, my lord, it will take long term, my lord. Only 3,000 rupees, my lord. Learned lower court directed to give only 3,000 rupees for maintenance and interim maintenance, my lord, and directed to prefer a room for staying, only one room, my lord.
No, this is a case of DV.
My lord.
What are you submitting? I could have
DV, my lord. At this DV, my lord, learned lower court on 24/2, my lord, domestic, the allegation of domestic violence upon petition of the respondent number 2 and his family members not proved. In this way, my lord,
not proved.
Not proved. In this way, my lord, learned judicial magistrate order, my lord,
You rejected your
my lord.
application. And that has already been upheld by the learned
additional session
appellate
judge. Yes, my lord.
Now, what stay you do want? And
my lord, the order of the learned additional session judge order on passed by the 24 December.
How it will help you?
Criminal revision petition, my lord, because, my lord, 3,000 rupees order to pay the as in the, my lord, to give the maintenance as the
Earlier?
Yes, my lord.
Now it has been stopped as it is
Yes,
dismissed.
my lord. Yes, my
So now how can your that execution can be stayed? There is no execution proceeding is not there.
No, my lord. During
If something is there for execution, then it can be stayed.
Yes,
Suppose arrest may be there, suppose money may be there, but your case is your petition is dismissed.
Yes, my lord.
So now what to do?
My lord, earlier, my lord, maintenance case also was
That is
going on.
not
Yes,
now,
my lord.
now not in existence. It
My
has already
humble-
been disposed of. Your petition is dismissed. Now at this stage, what to do?
Against that order,
Even suppose stay of the execution, how it will help you? Will it help you? Because your 3,000, I can understand. Initially 3,000, prayer for 3,000 or the order of 3,000 was there as a maintenance. But at present, there is no such order. So staying the execution, what execution will stay now? There is no execution at all. And staying of the person, you have against the order of this. If the order is entered, your order of the appellate as well as the learned trial court below is set aside, then matter may be remanded back or something may be done.
Kindly admit this petition, my lord, again.
We can admit the petition.
Yes, my lord.
That is
Yes, my lord.
hard. MSPB Board of Regarding Legal Aid Council appearing for the petition. There is a formal party here.
Gotcha.
Mr. P.S. Comfort, learned additional PP appearing on the from the office note dated 17/2/2026. It is seen that the services will be completed on the respondent number 2, but no one appears on no one has represented the respondent. Export. Okay. Sure. Considering the submission made by learned counsel, matter is admitted.
Kindly fix a date, my lord. Kindly fix a date, my lord.
Accordingly, the matter may be listed for hearing or hearing date. 24/3. We are fixing it on hearing day on 24/3 in the hearing column.
Highly obliged.
Hearing এ কোনো কোনো। What are like
Leave petition, Lordship.
how many? This is 41 out of supplement. Matter of fact, yes, what was the delay?
Back to lordship, my lord, it is my lord.
It is a
No delay, my lord. No delay. Only based on notice be issued, my lord. Only.
Leave is there, Lordship. Appeal against security.
it's a leave application.
My lord.
Whether service complete or not.
Okay, notice. How many respondents are there?
Two, my lord.
Two. State is one. One is state.
One is statement.
Person got acquitted is respond number 2.
My lord.
You both are SSS or
I am my lord. He is triple S. SS.
he is triple S and you are
My lord. I am SS A.
SS Aram.
A.
And it's double S.
Or Mr. SS Rahman. The appellant applicant. Mr. P.S. Notice the respondents to speak listed method. We are listing it after 4 weeks as on a date.
My lord. My lord. Highly obliged.
Oxford Metal Lordship, service Lordship. We have not received the service report, Lordship.
FOXO is there. Service report is still
Awaited,
awaited.
Lordship.
In this
We
case,
we have received the records.
Teacher is
the
You have not taken steps or what?
we have
Steps
taken
taken.
steps, my lord.
steps taken.
Steps taken. We have 9.
We have taken steps in.
Is there in there, Lordship. A gyroscope is also.
Oh, acha, acha.
Oh. My only respectful submission, your lordship, is he has been convicted and sentenced for a period of 5 years, and he is behind the bars for last 3 years and 3 months. Okay.
But your appeal is also supported with an IA.
IA, your lordship. So if your
But,
lordship may
as
kindly
this is a
consider my IA. No.
We need the receipt. Anyway, we'll do one thing as we have already received the TCR. So if any objection is there, verbal objection, they can submit before us after going through the case diary. It's okay. Now, as it is a POXO, so we have to comply with the provision. Anyway, you can take instructions in that regard because your office has already received the notice on 6/1/2020. To your office. Your office has already received on 6/1. Yes, anything.
Report not received, Lordship.
Huh?
Report we have not received. So,
No, you have not received. Your office has received the notice
Lordship. So,
on 6/1/2020.
and Lordship, may I fix it on a short date so that we can take instruction
Take
whether it is
instructions,
received or
okay.
not.
No, may I
Because
submit
as
your?
he has submitted 3 years, 2 months is already
No, no.
gone.
On
May,
Monday next, Lordship, we can fix it.
may I submit your lordship?
May not be possible. There are
Any date,
many
any date,
matters.
as per
Monday.
convenience.
Your lordship may be pleased to, if your lordship may kindly, be pleased to appoint an amicus, your lordship, in this case.
We don't know about the status now. If they on the next date, if they let us know about the status, if we know, then we immediately appoint him amicus. So we are giving a short date trying to give you a short list. Heard Mr. T. Deori, regarding for the appellant and also heard Mr. Swain. Service TCR has already been received, but as part of this note, the service is still awaited for the respondent number. In view of this, the additional PP thereby asks to take necessary instructions in regards to service of notice to the respondent. Let the matter be accordingly listed. Yes, block out when it can.
Any request?
11. 11 will be too long for you.
No, Your Lordship.
Okay.
Hello, Your Lordship.
Yes, in
Lordship, this is in the IFO correction of the AB order, Lordship.
Oh,
The order was passed on 18, Lordship. So
order
there
was
was,
passed on 18.
yes, Lordship, three correction in page 2.
Page 2.
Page 2, Lordship, of the original petition.
Now,
There was
where-
typical error on our part. That was the second line, Lordship. Daughter of. Sorry, son of. It was written as son of. So it should be daughter of. And Lordship in page
where you saying son of?
second page, Lordship.
Second page, which line?
Piakhi Sutia, aged
Cost title.
28 years.
In cost title.
Cost title.
Name of the petitioner. Name it. Lordship, this is the original application. Lordship.
Original.
Original application, bail application.
Original bail application.
AB application, Lordship.
Acha. In cost title, what was the?
Page number 2. Piakhi Sutia, aged 28 years. It was typed as S/O.
Son of.
Yes, it should be D/O, daughter of.
Acha.
That was the mistake on our part. Then, Lordship, in paragraph 4 and 5 of the bail order.
Paragraph 4 and 5.
Yes, Lordship.
In order.
Yes.
Yes.
In paragraph 4, Lordship, it was written at Poliobor Police Station. It should be Pulibor Police Station.
Pulibor.
Pulibor.
I looked at Pulibor.
Pulibor Police Station, Jorhat. Only that Poliobor.
Should be
And
Pulibor.
Yes.
Pulibor.
PULIBOR.
Pulibor police
Para
station.
4
And then
of the bail order. And in para 5 also, Lordship,
Hmm.
it was wrongly written as Polibior. It should not be, yes, it should be Pulibor.
Pulibor. Pulibor police station.
Police Station, Jorhat.
Mr. Deola regarding Mr. Yes, litigation PP appearing. This is an application. This interlocutory application will file for correction of the cost and of the bail application. Bail application number
337/2026.
and also for correction the modification earlier interim order dated 18/2/6. Next right is submitted by Mr. Ulla that inadvertently in the cost title of the earlier bail application it was named as the petitioner is named as a Priyakhi Sutia, son of Jitu Sutia, which ought to have been daughter of Jitu Sutia, and in the same time, in para number 4 and 5, the name of the police station is written as a Poliobor, POLIOBOR, Poliobor police station, and Kalibior, Polibior, KOLIBIOR, respectively, which is ought to have been named as a Pulibor, PULI.
PULIBOR.
PULIBOR, Pulibor Police Station, Jorhat.
In para 4 and 5. Lots of direction may be given to the registry to correct the, because it was in the system.
It is in the
because my post title name is in the system, Lordship. If it is in the order,
That I can.
no, direction may be given to correct the name in the post title because Lordship, the case is pending. Always, Lordship, it
What is
comes.
the procedure? Can you tell us? In the bail order, we'll correct and paste the order
Yes,
immediately. But this post title is already reflected in there.
Reflected in there.
That I don't know what is the procedure. Procedure.
Lordship, with this.
The bail order dated 18/2/2026 will be now read as per my report. Further, the registry is hereby directed to correct the post title by ascertaining the word daughter of in place son of if it is already deceased with the above bracket. It
Like.
will be, but we'll see to it, we'll see.
Like.
The rest is directed, I don't know the procedure exactly, it may be corrected, I don't know.
Look.
If it is